Wait, is it also? Malad, this matter relates to payment of pension, family pension, my lord, to a divorced daughter. The petitioner is the divorced daughter, my lord. She got married on 5/3/1998.
There is some order passed by the court,
Yes, my lord.
coordinate bench.
Court bench has passed similar order at page 32, my lord. It has been held that my lord, the
Read this order.
my lord. May I read the relevant portion, my lord?
No, read the. Let us understand what are the facts.
My lord, my lord. The extrajudicial jurisdiction of this court is sought to be
You start from para 3 onwards.
My lord. The mother of the petitioner, late Mahmuda Begum, was working as Khalasi against a substantive post under the establishment of the respondent number 3, that is the Executive Engineer Public Health Engineering Department. The mother of the petitioner had died in harness on 17/10/2018, by which time the mother had served for 22 years, 1 month and 8 days, which was qualifying service, leaving behind the petitioner, who is the only next of kin, and was solely dependent on the income of her mother. Though the petitioner got married on 30/12/2013, she was divorced on 24/9/2014 and had thereafter lived with her mother. Upon the death of her mother on 17/10/2018, the petitioner had applied for family pension, DCRG, and retirement benefits on account of the service rendered by her mother. She had accordingly submitted form number 19 and form number 3. However, by communication dated 6/8/2019, such entitlement was declined. It is this action of the respondent authorities declining the family pension to the petitioner is the subject matter of dispute in this writ petition. Paragraph 6, my lord. Sri Soikia, the learned counsel for the petitioner, submits that the present case is a case where the father of the petitioner had passed away long before her mother. A scheme was introduced by notification dated 14/9/2017 by the Finance Department, the subject scheme for compassionate family pension in lieu of compassionate appointment, which in short is also known as compassionate family pension scheme. As per the said scheme, the primary objective of the policy had deemed to support the family of the employees who died in harness, who was the sole winner of the family, as a stopgap arrangement, and if the family managed to sustain themselves for 3 years after the death of the employee, there was no ground for compassionate appointment. Hence, to replace the existing policy of the appointment on the compassionate ground, the present CPF scheme was introduced. Under clause 5 of the notification, guidelines have been laid down, the relevant parts of which are extracted herein below. The applicable definition of family of the employee dying in harness will be definition of family that is given in the Assam Services Pension Rule 1969. The counsel for the petitioner had reiterated that the petitioner got divorced much prior to the introduction of the scheme by notification dated 14/9/2017. The learned counsel had also drawn the attention of this court to the Assam Services Pension Rule 1969, more particularly Rule 143(1)(d), as per which the family pension for the purpose of rules will include unmarried minor daughters. Attention of this court has also been drawn to the amendment of the scheme, same by notification dated 9/8/2018, whereby the word unmarried minor daughter have been replaced by unmarried dependent daughter. Further, a proviso was also been inserted, which is as follows: provided that family pension shall be allowed to continue beyond 21 years of age to an unmarried dependent daughter of a government servant pensioner, subject to fulfillment of the following conditions. It is the submission of the petitioner that the legislature in its wisdom, has replaced unmarried minor daughter by unmarried dependent daughter. As regards the meaning of unmarried, Sri Soikia, the learned counsel for the petitioner, by referring to the Black's Law Dictionary, has contended that said expression would also include a divorcee. For ready reference, the same is extracted herein below. Unmarried. Its primary meaning is never having married, but it is a word of flexible meaning that it may be construed as not having a husband or wife at the time in question, example, widow, widower, or divorcee. The learned counsel for the petitioner submits that similar issue had also come up for consideration in various courts. The following decisions are relied upon in support of his submission. In the case of Kusum Devi Supra, the Honorable Allahabad High Court has held that a divorced daughter, if dependent on her father, cannot be excluded and has to be included within the meaning of the word family and has to be treated at par with the unmarried daughter. In the case of Khazani Devi Supra, the Honorable Punjab and Haryana High Court was dealing with a similar situation concerning the pension of a freedom fighter. A learned single bench of the Honorable Court had initially held that the main thrust was towards the monthly income of the daughter of the deceased freedom fighter, who would not be entitled to pension even if she is unmarried and widowed in case she is employed. The petitioner could have explored the source of income by seeking maintenance under Section 25 of the Act, as the law provides that she can move an application at any subsequent time to the passing of the decree of divorce. The claim was accordingly rejected. The matter was taken up in appeal before the Honorable Division Bench, which, however, reversed the decision of the learned single judge. The relevant observation is extracted here and below. The underlying object in the clause of the scheme listing eligible dependent is that only one be granted the pension. Therefore, the authorities have to construe the admissibility of benefit from that angle. It is not the case that daughters are excluded altogether. An unmarried daughter finds mention in the list of eligible dependents. It would thus be travesty to exclude a divorced daughter. There would be no rationality to the reason that the unmarried daughter can be included in the list of eligible dependents, and a divorced daughter would stand excluded, particularly when she is the sole eligible dependent and thus qualifies of the benefit, which is
What happened in your case? You were the unmarried daughter,
I am
divorced
the-
daughter.
I am the divorced daughter, my lord.
Where is the order of divorce? Or is
My
it
lord,
a
page
divorce
16,
by
page 16, my lord.
mutual consent?
Yes, my lord.
Divorce by mutual consent?
Yes, my lord.
Hmm. What is your status now?
I am still unmarried, my lord. Divorce was on, my lord, 29/7/2002. Mother predeceased, my lord. Mother died on 21/6/2005. Petitioner was with the father till his death, and he died on 23/10/2020, my lord. Thereafter she applied. Authority, my lord, did not consider her case. That is why she has approached this honorable court, my lord. Thank you.
This is ex parte, no appeal.
No appeal.
Yes, respondents, what do you say?
Only issue is that entitlement had already been decided. Only aspect, the petitioner is working as an Anganwadi worker. She is getting 6,000 per month.
She's not dependent.
Whether she is dependent, that is the issue, lordship may decide.
That doesn't make her dependent. What is there to decide? If she's working,
I have also filed an additional affidavit whereby I have said, I've annexed her medical reports and the certificate issued by the Gambura ballot. Page 46.
in the
Paragraph two-
judgment that you have relied upon, that was the issue was whether the daughter was dependent on the mother.
That was left to the authority, my lord. Only issue that in the judgment, my lord, it was decided that divorced daughters are also
Are
entitled.
also entitled.
My lord.
That's right.
And
Now
my lord,
here, what is your prayer?
page 11, my lord.
You are seeking a direction for release of family pension.
My lord.
So you'll have to establish that you are dependent.
Yes, my lord. Page 44, lordship may kindly.
Yes.
Paragraph 2, my lord. That the opposite case was filed by the deponent seeking for a direction for payment of family pension on death of her father and due retirement benefits with retrospective effect from 23/10/2020. Since her divorce in the year 2002, the deponent had been permanently residing with her parents and was solely dependent upon her father, as she had no other source of income. Her mother, who predeceased her father, died on 21/6/2005. Bad luck chased the deponent again.
The issue, the criteria or the eligibility for being considered is whether you are dependent.
Yes, madam.
Now, if you're working for whatever honorarium or salary, whatever
Madam.
you're getting, it doesn't make you dependent.
Madam, I am not 6,000 per month. Madam, she is
Very
old lady,
maybe.
madam. Present now she has become aged, madam. She is suffering from various ailments, and madam, she was dependent.
You tell us that that some material to show that how to expand the definition of dependency.
Madam, page 50, Lordship, kindly turn to page 50. This is the certificate issued by the Gamp.
How will the Gambura know?
Gampura.
How will the Gambura know?
He knows the condition of the villagers, madam.
Is this a certificate to rely on somebody's sustainability?
These things has not been controverted by the respondents, madam.
No, but you see, it is one thing to say that you are dependent. It is another thing to say that you are not dependent, but whatever you are earning is not sufficient.
Yes.
Does it make you dependent? No.
If my earning is not sufficient, madam, then definitely I will be dependent.
If your earning is not sufficient, is not a criteria. And how do you measure this sufficiency of earning? For you, 6,000 is not available. For somebody, 60,000 may not be sufficient. How do you make it? Your right to pensionary benefits is only as per the rules.
Madam, Lordship may direct the authority to consider my case for payment of pension, madam, considering my assessing my dependency, madam.
No.
As has been done in the other case, my lord. In the other case also, madam, the authority was left open, madam, for assessing the dependency factor, my lord.
No, in the other case, it was a clear case that you are not employed.
Yes, madam.
Here is a case you are employed.
Madam, paragraph 32 and 33, page 42, my lord.
30?
33, my lord, paragraph 33, my lord.
Yes. The dependency factor,
Yes,
the finding of the court is that she was dependent.
yes.
Here, that finding cannot be returned.
You know, she was relying on her father only, my lord, till the death of her father. She admittedly, my lord, she gets 6,000 rupees, my lord. That perhaps is not sufficient to maintain a, my lord, healthy life, my lord.
Yes, respondent, what do you say?
We have filed our affidavit, Lordship, in paragraph 6 of our affidavit, Lordship. Running page 44.
Yes.
May I read, Lordship?
Hmm.
That with regard to the statements made in paragraph 3 of the writ petition, the deponent begs to state that regarding the date of birth, marriage.
Para 44 is an affidavit filed by the petitioner. Additional affidavit.
No, Lordship, this is
I'm sorry,
Page-
page 44.
page 44 is ours, Lordship. That is respondent number 2, running page number 44.
Yeah.
I think
By Samsul Alam.
some sort of.
Yes.
That with regard to the statements made in paragraph 3 of the writ petition, the deponent begs to state that regarding date of birth, marriage, and degree of divorce dated so and so are the matters of records, and the deponent does not make any comment on the matters. However, the deponent begs to state that in terms of Rule 143(1) and 2 of the Assam Services Pension Rules 1969, amended from time to time, and the Government of Assam Pension and Public Grievances Department OM number so and so, there is no such provision for family pension to the divorced daughter of the deceased pensioner. Further, the deponent begs to state that in connection with the instant case in WPC number so and so, Office of the Principal Accountant General, within bracket A&E Assam Beltol Guwahati White Communication number so and so, cited the above rule of 143 and stated that pension, family pension, and other retirement benefits of the employees of the Government of Assam is governed by the Assam Services Pension Rules 1969 and not guided by the CCS Pension Rules 1972. However, the petitioner's current engagement as an Anganwadi worker with an honorarium of rupees 6,000 per month indicate a source of income which may affect the determination of dependency as per applicable pension rules. The deponent further begs to state that as per notification dated so and so, to enable a daughter for a pension of a deceased father, a certificate of non-marriage and non-employment is prescribed in the format duly certified by the CEO/VDO concerned and shall be furnished by the unmarried dependent daughters to the treasury or bank once in a year. Lordship, we have annexed one letter, Lordship, that is issued by the AG as Annexer 1, which is at page 49. 3/7/2023.
Yes.
3/7/2023.
Hmm.
Here, it's been clearly written, Lordship.
No, clearly written. Have you put up the papers and sent to the AG?
Yes, Lordship, we have. এখানে তো চিঠিস না সেখান
Okay. Was there any appeal against the judgment? Pronita Kolita? No appeal.
Against Hasiba Begum, my lord.
No, in this Pronita Kolita?
This
No,
is the
sorry. What is the other?
Hasiba Begum.
Ah.
Hasiba Begum. No appeal. They have complied with the order, my lord.
So in this case, Hasiba case, Begum is not applicable, Lordship.
Why?
It clearly stated that dependency, she must be proved the dependency, Lordship.
No.
In the Hasina Begum case,
No.
Lordship.
In the annexure which is being referred to, it's a communication from the Office of Accountant General, Mr. Borua.
Here, we have
Your case is that there is no provision for divorce daughter.
Yes,
That is already settled by this court.
no, that's fair, yeah, because what we do, Lord, as the AG I'm submitting, if it is in this, that position should be clarified. We are writing later.
Can be clarified in every case.
No,
This is the
yes,
law laid
this
down, it is
particular
binding.
case, this particular case,
Yeah.
this my learned friend has just not pointed out, submitted before Lordship, dependency should be proved. That that Hasiba
No, the
case is
first
there.
thing is whether divorced daughters are eligible or not,
No,
number one.
not.
So if you reject it, then you'll have to give an answer to the judgment of this court.
No, this, if
This
it-
judgment was delivered and as per the submission of the respondents. In the judgment also, Accountant General was a party. You have complied with the order. How can you now turn around and?
no, that judgment, it is a dependent, it is last to dependency must be petition. This is to be proved by him.
There are two issues. The first is whether a divorced daughter is
No.
available or not. That has been settled.
Yes.
You can't deny it now unless you go and appeal. This is binding on you,
Hmm.
including Accountant General.
Hmm.
The only other aspect is whether it is dependency is there or not.
Yes, if it is established,
Huh.
if it is established, is the dependency is established.
No, you see
Then-
your letter. Your letter, you are rejecting it on the ground of the fact that she's a divorced daughter.
Yes,
No provision.
I know. This part, Lordship,
Hmm.
yes, this is, because we are a decision. But dependency has to be.
You are
That's,
referring to-
I'm getting, my lord, I'm getting it, that two parts, it is first 2 year
No,
rejected
you
on
have
the grounds of
rejected it.
this.
You have
Therefore,
not even
that
gone
is not
into
entitled.
dependency. You have not gone into dependency. You rejected it on the ground of being a divorced daughter because the rules don't conceive of divorced daughter.
No, that order letter, judgment, it is,
18, itu masih berapa itu? Masih
then we'll look into, we'll discuss the matter,
19.
because, this letter, we are telling this, this judgment, whether it was placed or not, this is to be, I'll take it a clarification whether this, how to be treated now.
Part of the writ petition. Manoj, this communication was issued,
You are still employed.
Yes,
Manoj, I am doing the honorary
So how
service.
do you satisfy the dependency?
Manoj, Anganwadi, employee engagement is not an
Mr.
appointment.
Counsel, you are addressing a case before a court of law.
Manoj.
So mere submission doesn't help you. You have to justify that this notwithstanding the receipt of 6,000 per month does not satisfy the criteria of dependency. What are you relying on any authorities to at least point out what is dependency and how it is to be?
This, Manoj, on this issue, my
Accepted.
final authority, my lord. On this issue, my lord, final authority, I have searched it, my lord.
Hmm.
But my lord, as far as certificates is issued by the Gambura and the my lord,
You're
medical
going back to
certificates.
Gambura
and the medical
is
certificate-
Gambura is not even a concerned person.
Yes, the medical certificate, my lord, also, my lord, it says, my lord, she is suffering from various ailments. And my lord, 6,000 per month, my lord. She is, that perhaps is not sufficient, my lord, she was dependent on her father. She was dependent on her father.
উঠাইছি মানে sanction cancel section of it এটা আপনার রোল আমার রোল
কিন্তু পঠাইছে নে নাই?
উঠাইছি না নাই উঠাইছি
চাব লাগিব,
For a lady, my lord, aged about,
আপনি নিয়ে বলেন
He's presently, my lord, she is aged about 52 years, 53 years. And my lord, she is suffering from various ailments also. She is alone, my lord. She is alone. No one is there to look after her, my lord. Her father was the only
These you go and urge before the administrative department and accountant general,
that my lord, that
not before a
regarding-
court like this.
I am not hiding anything, my lord. I
No,
have,
it's not
I
about
have-
hiding or
I
not
have-
hiding. It's
I
a
have
question
stated
of the
that
rules.
I am being paid 6,000.
It's the question of the rules. Your entitlement is absolutely determined by the rules. You're not putting the rules to challenge. We are giving you the benefit because there is already a judgment of a coordinate bench that divorced daughters are also included
My
to that extent. But dependency you'll have to satisfy.
possibly open to the authority matter to determine matter.
What is there to determine? You have admitted that you are earning, therefore you're not dependent according to them.
Leave it to your boss. Then I will leave it to your boss.
No, don't leave it to us. You have come before us. We did not invite you. Why are you leaving it to the court?
My lord, as per my instruction, my lord, my assessment, my lord, she is dependent, she was dependent on her father. She get only 6,000.
We
rupees
refer
per
to
month.
councils as learned councils. So you make us wiser on the next date. There are judgments in your favor, but you are not willing to look into that. Don't give it to the court. List again on fourth of December for further hearings. Mr. Ayat Sakia for the petitioner, Mr. C. Borua for accountant general, Mr. R. N. Das for public health,
Water resource.
water resources, Mr. A. Chakraborty for government of Assam.
Three and four.
Yes.
I'm for my lord. I. Like.
Timing number two.
Yes.
My lord, on the last occasion, my lord,
What instructions have you got?
Lordship, so far as that decision, Lordship, as to how to recruit in those 24 posts, Lordship, PNRD department has forwarded the file to the judicial department for their views, Lordship. But they were waiting for the views to be given by the judicial department.
What is your claim here?
my lord, our claim is, my lord, this is the selection of junior engineer, my lord. I am fall under the category SC category. Now, in the SC category, my lord, they have selected, my lord, SC PWD candidate more than the reservation post. Lordship, may kindly see the, my lord, 16,925 order, my lord.
You are an SC candidate.
My lord. No calculation for this person.
Now there is no stay order for the 24 posts.
Yes, Lordship.
And while filling this 24, what will be the percentage to be
No, so
reserved?
far as the claim of the petitioner is concerned, Lordship, he is at the top of the remaining SC candidates. Now, if if Lordship comes to the result, Lordship, at page 40, read petition, Lordship.
Hmm. Yes.
Lordship, may kindly see number of posts, Lordship.
320.
Appointments have been given in 320 number of posts.
Hmm.
And if Lordship comes to SC category, Lordship, in the second line, SC 12 have been given appointed, selected and given appointment. So
12.
initially advertised Lordship 13 posts. Advertisement is at page 25, Lordship. Relevant page is page 26. If Lordship comes to the table, there are 13 posts reserved for SC.
Hmm.
Now,
Where is the name of the petitioner?
petitioner's name is Rajesh Kumar Das. He is not there in the select list, Lordship.
Hmm.
He is claiming that if one of the candidate given the quota of SC from the PWD selected candidates, if removed, then he will enter the list. That is his case.
No, you say that in the list at page number 40,
Yes,
there are 12 SC candidates.
there are 12 SC candidates. Initially advertised 13.
13.
And he is saying that his position now in the non-selected candidates, he is at the top of among the SC candidates.
No, that is okay, but you had reserved, you had kept aside, you have filled up 12 posts.
12 posts, one post of SC is there.
One.
Among
one-
those 24 state posts, Lordship.
Hmm?
24 appointment in 24 posts were initially state, subsequently that was vacated. One SC post should be there.
So during this stay order of 24 posts,
Yes,
you decided to scale down and then have 13 posts, or it was 13 posts for
Lordship,
344?
initially it was 344 posts.
Oh,
24 post stay was there. Accordingly, we decided to give appointment in 320 numbers of posts. So select list was of 320.
so out of 320, 7% comes to 13.
No, out of 27%, 13, no, 12 Lordship.
12.
Out 344, 13,
Hmm.
320, it is 12.
12.
So 12 SC candidates are there.
Hmm.
But Lordship, his case is that he belongs to SC category, but some PWD candidates who are SC were given accommodation in the SC category. That is why his name was not there in the select list.
No, now these 24 posts are available.
Are available now.
So when are these proposed to
That
be
is
filled?
the reason, Lordship. Last time direction was issued to the authority to me, Lordship, to obtain instruction as to whether selection appointment in these 24 posts is to be given from the already selected candidate.
When were the selected candidates given?
List was 31st.
22nd.
Yes, 31st of May.
They are all appointed now.
They are appointed, Lordship.
This select list is valid for 1 year.
It was valid for 1 year, but in so far as one selected candidate is concerned, one stays still there, Lordship. My friend is appearing for another selected candidate. He is a PWD candidate selected in the SC category. So his appointment still under.
Is his appointment under challenge in this matter?
Yes.
There is a stay order.
He was not initially a party. Subsequently, he implemented himself, Lordship, praying for, as I am a selected candidate, be get for his appointment.
By which order was it stayed?
Lordship, I filed in 24/6/2022. In the third page of that order. The second paragraph. The last paragraph of the third. এইটা SC category
দুটা সোমাইছে।
ওটা ৰাজীৱ দাস আৰু
আৰু এজনী ছোৱালী এজনী আছে ন?
ৰাজীৱ দাস আৰু সুমন দাস
আৰু এজনী অনুৰূপা
আমি যদি যোৰপাত চাৰিটা ইংলিছ নহ'ব লাগে
তাই ওমেনত আছে।
ওমেনত আছে কিন্তু তোমাৰ নাম কি সুমন দাস
ইন্টাৰ আই এটা আছে নেকি? আই
অনুৰূপা কথা
হিচাপে চাৰিটা চাৰিটা
কেই নম্বৰ তাত?
তাই 10 নম্বৰ পাইছে SC category
আই
হেৰিয়ত
what is the I number?
798 of 2023
Which date? Order.
It's order dated in
One thirty.
24/6/22. It's at page 86 of it. I starts at page 86. The 11 portion is at page 87, the last paragraph.
Page 86.
Yes, Lordship, 85 is last. When the 11th one, the page 87, Lordship, last column. Good.
So one post in SC category. SC simpliciter means SC category. And one post in SC disability. And SC women, not to be filled up. So essentially 3 posts.
Yes, but so far as that SC woman is concerned, on wing file another application, Lordship, she has been allowed to
All right.
join.
So you have one SC simpliciter, one SC with disability.
No, if Lordship comes to page 48, Lordship,
48 of?
page 48 of the repetition. This is the select list, Lordship.
No, I'm referring to the order, interim order passed.
Interim order, 1 woman and 2 SC.
I know 2 SC,
2 SC.
one is SC simpliciter.
Yes.
No, Lordship, if Lordship comes to page 48, both were under PWD category, Lord. এই দুটা, এটা women আৰু plus এই দুটা।
48.
48, Lordship.
Ah,
Serial number 317 and 318.
ah.
These are PWD candidates, Lordship,
Hmm.
but accommodated against SC quota. So appointment of these 2 candidates plus 1 woman candidate were stayed by the Honorable Court. The woman candidate is at page 188, serial number 288.
Hmm.
Subsequently, she has been allowed to join in an application filed by the petitioner. And so far as this 318 is concerned, another application is pending.
Now these 2 persons,
Yes, Lord.
they would not have secured appointment in PWD.
They are selected against PWD category,
Ah.
but as they are SC,
SC.
they belongs to SC, they
Ah.
were accommodated in the SC. So that is the horizontal reservation concept, Lord.
Under the PWD Act, 1% is reserved for vision impaired Lordship. I am vision impaired.
Hmm.
Lordship. And now there are only 3 incumbents appointed, available to be appointed against those posts, Lordship. And I am the 3rd one, Lordship. One post, which was reserved for the vision impaired person, Lordship, that is still like within Lordship. So I would come in, Lordship, anyhow, Lordship. Because out of 320 posts, if Lordship considers 1%, then it would be at least 3, Lordship. So I would come in.
What you want to say, there has to be little amount of clarity. What you are saying essentially is that in view of the reservation, there are 3 posts available for PWD.
For vision impaired category under the PWD.
3 posts.
Lordship, 1% of 320 posts would be minimum of 3, Lordship, 3 posts.
So how many are reserved?
Lordship, under the advertisement, there were 4 posts reserved for vision impaired Lordship. Now, Lordship, my claim is that since I'm the third incumbent against that post, that vision impaired category Lordship. So,
Yes, APSC give us the list of breakup.
Yes, sir. Lordship may kindly come to my affidavit in opposition.
It is already there in the select list itself, Lordship. Page
Hmm.
48 itself, Lordship. If Lordship comes
No,
to the
no,
note.
this is the select list. You give us a breakup. This
Yes,
is the
that,
total
that,
number.
that breakup,
Yes.
Lordship, may kindly say
Breakup, we'll have
for,
to take
for
it
a
out
moment,
from here.
Lordship. Page 48, Lordship.
48.
8, Lordship, rate petition.
Yes.
2 points are there, Lordship, up at the end of the list, Lordship.
Hmm.
Second one, Lordship, there were only 3 PWD BI category candidates against required 4 candidates. Also, there were no candidate for PWD autism. So he is one of those VI candidates, Lordship. Advertisement was for 4,
Hmm.
but only 3 candidates were there.
What has happened to that one post?
That remain vacant, Lordship. So
Vacant.
initially 14 posts were advertised for PWD categories. Select list contains 10 names, Lordship.
Yes. Now, what do you propose to do with this one post?
No, that is outside 320, Lordship.
Hmm.
That is outside 320. So far as the 320 is concerned, Lordship, he is one of the 3 VI candidates, Lordship. So in any case, Lordship, he will come in.
Hmm.
Only issue, Lordship, whether he should be placed against a general category, as they are saying that he should not be placed against his SC category post.
Hmm.
That is the issue, their issue, Lord, their understanding, Lordship. So my understanding, Lordship, it has rightly placed in the SC category. It's a horizontal reservation, Lordship. He has to be placed in the category to which he originally belonged. Just like women candidates, Lordship. So far as 288, Lordship, serial number 288. Lordship, she is Anurupa Pathak. She was selected as a woman candidate, but she belongs to SC category.
Hmm.
So she has been accommodated in the SC category.
Hmm.
Subsequently, her appointment has been cleared, Lordship, by this honorable court itself. So now she has joined. But these 2 candidates are still to join, Lordship, because of the court's order. 317 and 318.
Who represents the other candidate?
Other is not before the court, Lordship. He has not been made party and he has not prayed for impleadment also. But they have entered by filing impleadment petition.
Yes.
My lord, our case is against 320 posts. Now, the initial selection was conducted against 320 posts. My lord, out of 340 posts, 24 was my lord state, 24 posts were reserved. So 320 posts against 320 posts, merit list was published. Now in the SC category, my lord, 12 posts were selected, SC general, my lord. And regarding this SC PW, my lord, they selected 2 posts. My lord, if it is, we consider SC PW as 4% horizontal from the 12, my lord, it will come only 1 post. So they selected, my lord, two candidates from the SC PW, my lord, horizontally. So if 4%, my lord, of 12, it is only 1. They cannot select 2. So if 1 is out, my lord, then I'm in, my lord. That is our case. And my lord, that's why, my lord, earlier occasion, this honorable court directed them to, my lord, produce this detailed merit list of the, my lord, merit list of the SC candidate, my lord. But till that has not been done by them.
No, no.
So
On
this
last
there-
My
last
lord,
3 to
but
4
that
occasion, I
is
have
not clear, my lord. That's
record.
why I'm saying, my lord.
So why is it not clear from?
My lord, kindly see. In their affidavit, my lord.
No, come to the select list. It is clear from the select list.
My lord, select list, my lord, this SC PWD, 2 posts has been selected. We are against that.
Hmm.
Is if that 2 posts, my lord, if 1 is outstate, my lord, then I'm in.
No, how can it be ousted?
My lord, because, my lord, PWD, SC PWD is horizontal reservation, 4%.
Hmm.
So total reservation of this PW, no, my lord, SC candidate is 12 posts. So 12 posts, out of 12, my lord, 4% will be 1, not 2. That's why initially this honorable court, my lord, they stated the 2 posts, my lord. Now they are, my lord, they are reserving, my lord, this horizontal post out of 320 in total. Not reservation wise, my lord. Kindly see the select,
Show us the law.
my lord.
page 96 of the IL.
Huh?
Page 94 it starts that act.
Okay, that was the problem.
Yeah.
90?
94 of the IL. This is the amendment. 34.
This IA is still pending.
Yes, Lord.
IA is filed by whom?
Why?
By you.
Suman Das Lordship.
Who is Suman Das?
He is serial number 318 in the select list.
Who represents?
He is
This is an IA for what? For vacating the interim order. Yes, page number.
Page 94 it starts and page 96 is relevant. Paragraph 34. Every appropriate government shall appoint in every government establishment not less than 4% of the total number of vacancies in the cadre strength in each group of posts meant to be filled with.
No, we are not able to find it. 94,
96.
96, Mal.
96. Paragraph?
Paragraph 34 also.
Yes.
Every appropriate government shall appoint in every government establishment not less than 4% of total number of vacancies in the cadre strength in each group of posts meant to be filled with persons with disabilities, the benchmark disabilities of whichever 1% each shall be reserved for persons with benchmark disabilities under clauses A, B, and C, and 1% of persons with benchmark disabilities under clause 1 and E, namely A, blindness and low vision. This is the category which I am claiming. And then B, deep and hard of hearing, and C, locomotor disability, including cerebral palsy, leprosy, practically affect victims in muscular dystrophy. So my 1% comes within that A lot.
blind.
Out of the three.
1% to 320%. No, can I think of it?
Dear Lordship, the main stress Lordship, 34-1, it is cadre strength, so not the vacancies. So his basic.
No, total is 4% of the vacancies in the cadre.
Cadre.
These are,
So total vacancies available in the cadre,
yes,
you reserve 4%. Out of the 4% on these categories, you reserve 1%.
1%. Cadre, तुम्हारा vacancy होगा, total vacancy that we are not full. The right center तुम्हारा क्या? 4%. ये बसों सेट अप तो नहीं होगा, तो जो PWD कैटेगरी है वो तो PWD है।
My lord, in that case, my lord, they have to provide the cadre strength. And Lordship may kindly see the affidavit filed by
No,
the
it
APSC.
says total vacancies in the cadre strength.
Yes.
The vacancies are advertised, 344. 344.
So in that,
What is 4% of 344?
Initially, it was 14 Lordship
Hmm.
in the advertisement Lordship.
So out of that 14, you have to reserve 1%.
Yes, Lordship. It's, if Lordship comes to page 25, last column Lordship. 26
Of the writ petition.
petition.
Yes.
26 last column Lordship. Post reserved for PWD and type of disability 14. Lordship may kindly see VI 14 blindness. 4. But only 3 candidates were there, so far as BI is concerned. Lordship has seen the select list, last point, Lord.
Okay, very good line. In the book, right? In the book.
Lordship may also see the other PWD candidates, Lordship, who were placed against which category, Lordship. If Lordship comes to page 45, Lordship. Page 45, Lordship. And if Lordship comes to the last but one column, Lordship, that is PWD, top. At serial number 213, Lordship, he is orthopedically handicapped. He is a general category candidate. So he was accommodated against the general sales. Same Lordship 219. He is orthopedically handicapped, but accommodated against general category. Then Lordship, PWD at page 47, Lordship. Page 47, serial number 293. He is visually impaired. He is a general category, Lordship. Then if Lordship comes to 310, he is again general category. 313, visually impaired, he is a general category. 315, Lordship, he is MOBC. So he has been given accommodation in the MOBC quota. And 317 and 318, both SC, belongs to SC. So if somebody selected against the PWD quota, Lordship, he has to be accommodated in the category to which he originally belongs, Lordship. And the posts for the PWD candidates are already earmarked, Lordship. That has already been fixed.
No, but you had reserved 14 posts.
Initially 40,
Ah,
but some candidates were not there. In the select list, Lordship will find 10 names, Lordship.
10 names,
10
yes.
names.
What happened to the balance 4?
Lordship, in some categories, Lordship, candidates were not there. And so far as this BIE candidate is concerned, Lordship, that is there in the node itself. Yes, only 3 candidates were available so far as BIE is concerned, Lord. So one post of BIE still remain unfilled, Lordship. So at this stage, Lordship, he may be allowed to join his post, Lordship, as he is a selected candidate. So far as 317 is concerned, he is not before your Lordship.
317 has not joined. There's a
Stay
stay.
is operating against him also.
But stay, I thought, was only for 3 categories.
3 persons.
Ah,
One has been subsequently allowed Lordship. He is a woman candidate.
women candidate.
And against these 2 are still
One
operating
is simpliciter, one is VI.
Person will leave with
Huh?
disabilities.
with disabilities, Lordship.
So where is that interim order again?
Person with disabilities. Yeah, in
HI.
that interim order lordship will find at page 87 of the I.
One is SC simpliciter, one is SC with disability.
Yes, lordship.
So why is the other person not allowed to join? Women has joined.
She has been allowed.
So one is SC category simpliciter, one is SC with disability. Anyway, that we are not clear about.
Yes,
Right, yeah, so getting part by disability.
disabled.
Don't enable that.
You know,
Yes, Mr. Sinha.
My lord, these 14 posts, It
So
is,
you, on what ground are you making this submission
my lord,
that they are disabled and they're SC, so they must be accommodated in disability, not in SC?
no, my
That
lord,
is what
kindly
you
see.
say.
In this select list, my lord, they have reserved 14 posts out of 320 posts. My lord, 4% for PWD. And it is for all the category of, my lord, post, not for only SC. So SC reservation is 7%, my lord. So SC post is, my lord,
No,
12.
no, all category means all category of physically, the person with disability, the disability categories.
Disability category, my lord, 14 posts out of 320 total posts.
Right.
So that this 14 post has to be divided between all the category of reservation. That means general OBC, MOBC, ST, SC. Lord, in this category, my lord,
Not divided. Whoever is selected in the 14 will have to be accommodated in the other category, which
no, my lord,
reservation
in
category
that
which
case,
they
my
fall.
lord, they have to show us that in this, my lord, SC PWD category, the cadre strength, in the cadre strength, in total cadre strength of the post, this SC PWD 2 posts are vacant. Now, there in their affidavit, they have simply said,
Two posts are vacant.
my lord, they have simply said this.
There is an interim order.
Yes, my lord, interim order is there. My lord, I'm
Or it
regarding,
is at your instance that an interim order is there.
yes.
No, then
My lord, our question, our case is, as per 12 posts, 4% will come one only, PWD, SC PWD. So they selected
no,
two.
why 12?
So 12, my lord, out of 320, my lord, SC reservation is 12, my lord, 7% is 12 posts only.
Hmm.
So our case is, out of 12 posts, my lord, if 4% is, my lord, calculated for horizontally, my lord, SC PWD, it will come to one post only. So they selected two posts. So if one is outside, my lord, I will in this selection, my lord. Now in their affidavit, APSC, my lord, they have given the details of the case, but where is there is no post of PWD, my lord. Lossi, may kindly see the affidavit filed by the APSC, my lord. My lord, page 79.
Yes.
My lord, page 79, my lord. Lossi, may kindly see page 79.
Hmm.
Post to be reduced as per Honorable High Court order so and so. 24, the number of posts against which the category wise breakup of the post is showed 320. So, my lord, out of this 320, can I say open category, my lord, 133, women, my lord, 40, OBC, my lord, 83, women 25, SC 12, women 4. So they didn't show, my lord, this PWD category, my lord. There, as per them, there is no post of PWD SC.
There is nothing like PWD.
No, there can be a PWDSC.
My lord.
They'll have to be selected and given appointment in the category which they are.
My lord, in this case, my lord, in that case, my lord, my prayer, let them show us the, my lord, cadre strength of the SC PWD. Now they simply say,
No, how
since
can there be a cadre strength of SCPWD? There can be a cadre strength and you can be, there can be a division of category wise, how many posts of the cadre strength are reserved for SC, ST, STP?
yeah, my lord, that is
But
there, my lord.
this is
Now
horizontal.
regarding, my lord, the 4% is out of total vacancy. If we consider that out of, suppose, my lord, in the cadre strength of SC, my lord, candidate, 30 posts are vacant, my lord. Out of that, 4% is only entitled for, my lord, appointment, if the selection is made. Now here, they simply say that 2%, two candidate has been, my lord, found SC PWD, so we have selected. In that case, they have to show us that, my lord, two candidate, my lord, two posts, my lord, in the cadre string of SC PWDs are available, vacant. That was not so, my lord, that detail has not been given before this court. And, my lord, if we will simply, my lord, calculate, my lord, out of 12 is 4%, my lord, horizontally, if PWD, SC, PWD. In that case, only one post is entitled by
In any
PWD.
event of the matter,
My lord.
the select list is of 2022.
My lord, that's why, my lord, always there is an interim is operating, my lord.
No, the interim is only for these 3 posts.
Yes,
One of them has already been vacated.
vacated. So out of 2 is there, my lord. One is simplicity and one is, my lord, SC, physical disability, my lord. Well, let them show the cadre strength of the
So,
SC.
Mr. Nayak, I am unable to understand this SC simpliciter. Who is there in SC simplicity?
General, open category.
Huh? So
Lordship,
who is the candidate who is selected there?
Yes, one is the as per code direction, one SC in open category, one SC in PWBD and one SC in women.
Now, if this SC simpliciter category
Lordship,
is made available,
Lordship.
who is the candidate who will be selected? In this, from the select list?
No, already he is selected
Who
out of that 12 candidate. One SC general open category candidate was directed to be kept vacant, and one PWD category open male candidate was directed to kept vacant and was female. That female candidate, Lordship, and that stay was withdrawn, was modified. Now, Lordship, the one post of SC simpliciter, that is open category, and one post of SC PWD candidate are kept vacant.
We understand he falls under SC PWD.
If Lordship, his pair is allowed,
Uh,
his post is not affected. Because he fall under SC PWD.
uh.
So if he has at all any case, he will be vying for that SC simpliciter post.
That's right.
Against him.
We are asking you who is affected
Yes.
by the stay of the SC simpliciter.
In my affidavit, Lordship, I have given the third Lordship who were selected under the SC category. Lordship.
You're not understanding the
Yes,
question of the
Lordship.
court. There is an interim order.
Lordship,
So-
Arup Das,
No, he is not before the court.
not before the court,
Not being made a party.
not being with party also.
Is he interested in joining the post? Perhaps he is not interested.
Join কৰিলে নাই, join কৰিব দিয়া নাই। Because এইটো মেইন Arup Das last candidate. ছটা আছিলে। Lordship, kindly have a page 73, Lordship, for one moment.
Yes.
76. Lordship, it is in my affidavit in opposition, Lordship. I have given, Lordship got it. Page 76. Sorry, 73, Lordship.
Yes, 73.
70. Lordship, these are the 12 candidates who were selected against the SC quota, Lordship. Lordship, that is from serial number 1 to 6, those are the male candidates. And 7 to Lordship 10 are selected as a female candidate. Last Rajiv Das and Sumana Das, 11 and 12, they are male candidate, but they have entered as a PWD candidate.
PWD.
Lordship,
So out of this, whose post is vacant?
Lordship, that
Serial number 12.
serial number 12 post is vacant. So,
No, 12, no, which is under stay?
12 is
Serial
under, 12 is state
12 is stayed.
12 is stayed.
And 10 was also stayed
initially.
but it was vacated.
Right, 10 is vacated. Then
Vacated.
from the simpliciter,
Simpliciter, Lordship, this 6 should be the last person, Lordship.
so what has happened to 6?
That government will know, Lordship.
What has happened to 6?
That specific, Lordship, I have to bring.
That government.
Verify and tell us. If this person has already joined, then he has to be added as a party.
Lordship.
Yes.
Suman Das.
And how can he be allowed to join in view of the interim order?
Yes, that is why he has filed a vacating petition, Lordship.
He's filed a vacating petition only for 12.
Yes, but 10 is, so far as 6 is concerned, Lordship, he is not related. 6
That's
is,
right.
12 is VI category.
That is
PWD.
what we are asking you. The interim order is for,
Interim is for 3 categories,
Three
Lordship.
posts.
SC category, simplicity.
out of that, one has been vacated, women.
Women has been vacated.
One, he is available. He's affected, he's filed an application for implement and
Yes,
vacating.
that is
etc.
pending. And so far as SC category simpliciter is concerned, Lordship, no one is appearing, Lord.
So
Yeah, he should
has
be-
anyone been
does
appointed?
What I am submitting,
My
Lordship,
lord, as per my instruction, my lord,
Wait, let us finish with him.
Lordship, what I am submitting, Lordship, at all, if he has to compete, Lordship, it is with serial number 6, Lordship.
Serial number 6, whether the candidate is interested or not interested.
He has
Whether he
joined or not,
joined,
that,
what
that's.
is he done?
Yes, Lordship, that's.
Yes.
specific.
my lord, as per my instruction, my lord, Arup Das, serial number 6, he has already joined other department, my lord.
So you get that information.
Yes, Lord.
You get that information because otherwise this stay doesn't make any sense.
Yes, Lord.
Keeping it vacant.
Lord. But
Till now, he are.
ultimately, Lordship, so far as 6 is concerned, if he has joined other department, Lordship, there is no question of making him a party. And so far as 12 is concerned, he is before your lordship. But in any case, lordship, you will not compete with him. And so far as his own selection is concerned, lordship, he is not in the select list.
He may not be, but his claim is with regard to one SC post. That will examine it once you give us the information whether 6 is available or not.
Lordship.
When can you give us?
Next week, lordship. Any day, lordship. Monday, Tuesday.
After lordship, 5th of December.
Kindly, if it is fine.
Third council for purpose. The petitioner before this court is agreed by his non-selection. The post of junior engineer within bracket civil in the PNRD department.
The serial number do not know. They modern line.
Stop petitioner claims to belong to
Main list of
SC category.
Main list of
And he has been wrongly, according to the petitioner, he has been wrongly
Last of all, Rajiv Das Sumanda Singh.
not given the selection, not included in the select list,
First page only option মানে হয়।
as the department has
একটু বর্ণালী করে।
included
তো female option।
more than the specified category for persons with disability under the SC category. So, it is the claim of the petitioner that instead of one PWD SC category, they have appointed two PWD SC category. It is the submission of the council for the petitioner that if one of these SC category, one of the PWD SC categories that it is selection is interfered with, then the petitioner would be included in the select list for the SC category. So, during the pendency of the matter, an interim order dated 24/06/2022 was passed by a coordinate bench of this court. This interim order still subsists. In terms of the said interim order, one post each in SC category simpliciter, SC persons with disabilities and SC women were directed to be not filled up. So subsequently, the interim order was modified
By the order dated 5/1/23.
by order dated
2023.
5/1/2023, whereby the SC women post was permitted to be filled up by the selected candidate. So it is the submission at the bar that the said women candidate had since joined in the said post. So, however, the interim order still subsists in respect of keeping one post each vacant. One post each vacant in the SC category simpliciter and SC persons with disabilities. So, the applicant in IA number
798 of 2020.
798 of 2023 claims to be this selected person for the SC persons with disability quota. Stop. In view of these interim order passed by the court, he has not been able to be appointed by the respondents, notwithstanding that he is a selected person. So, It is the stop. Subsequently, the court had also granted liberty to the respondent counsels to apprise the court about the status of what were you supposed to apprise the court?
Lordship, whether in this 24 post, Lordship, a new recruitment is going to be held or will be from the already completed
Apprise the
recruitment?
court regarding the posts which were although advertised, not filled up by way of the advertisement dated so and so to the extent of 24 numbers of posts, and as to whether these posts, if whether the government has taken a decision, if these posts will be filled up from the said select list or by inviting a fresh advertisement.
From the said recruitment, Lordship.
Huh?
Select list is of 320,
No,
but recruitment was same, Lordship,
No.
43,
would be filled up. 24 posts would be filled up under the recruitment which is under consideration in the present proceeding, or steps would be initiated for a fresh recruitment. So the learned additional AG appearing for the state submits that the matter is, instructions are still awaited as the matter is presently before the judicial department for an OPD. So, where during the course of the hearing, it also appeared to the court that the applicant was filed IA number 798
Yes.
of 2023 is the person who has been selected for appointment in SC persons with disability category. So, however, although there is an interim order to keep one post vacant in SC category simpliciter, no affected person is yet before the court. So, under such circumstances, this court is of the view that perhaps the selected person may have either already joined in the said post or have opted for some other service stuff. These instructions, however, are not available with the government council as on date. The government, the learner additional AG is therefore permitted to complete his instructions as with regard to the candidate who was selected for the post of SC category simpliciter, which has been directed to be kept vacant by the interim order dated so and so. Let these instructions be placed before the court on
after 5, Lordship. Any date after 5, Lordship.
on 9th
9th.
of December.
May not it possible 11, my lord.
No, 9th. Let it be on 9th. You come make your arrangements.
It should be disposed of.
Huh?
It should dispose of on that.
We'll try. We'll try. There is no point giving piecemeal order. We would have vacated your interim order, but we want to find out what is the
Lordship, keep this as part of
Information.
Lordship. Lordship is extensively hard, Lordship. Lordship, keep this part of.
We'll direct matter to be listed for further hearing. Further hearing
Lordship.
on 9th.
May please, Your Lord. Lordship, the petitioner before Lordship is initially appointed as a master roll worker, Lordship. He was continuously in service. Later on, Lordship, one FIR was lodged against him, and on the strength of that FIR, Lordship, he was being removed from the service. Actually, Lordship, the FIR was lodged because the petitioner has also lodged an FIR against a person
who has asked the petitioner to that she will provide jobs to the son of the petitioner. And believing her words, lordship, the petitioner believed her, but subsequently she did not turn up. So petitioner, I'll file one FIR, but the seeing that senior lordship, the other who friends of the petitioner son also has approached that person, and she took some amount and she left the place. That person self lost the FIR against the petitioner also. Petitioner has submitted several representations also that was not disposed of by the respondent authorities also. Respondent has filed their, if it's in the case, and lordship on earlier occasion, lordship, this one court has asked us to provide any order to show that whether
মানে দি পেলাই দেখাই দিয়ক, তাৰপিছত মোক জনাব কি আছে যদি মাৰ্ক কৰি দিম। দুপৰীয়া মাতি দিওঁ, ভলিউম এট 1 o'clock. Yes.
the on earlier occasion also, this honorable court has directed us to bring on record any order showing that whether our work has been extended.
Where is the order of, where have you been prevented? By which order?
Lordship, there is no any order.
What is
Only-
your appointment order?
Lordship, my initial appointment order is, Lordship will find at page 19, Lordship.
Yes.
Just type copy, Lordship.
You are the petitioner,
Yes, Lordship.
Binoy Kumar Bora.
Yes, Lordship.
You are appointed temporarily as a library attendant.
Yes, Lordship. And my appointment has been extended from time to time. That document was brought on record by filing.
Now, is there any proceeding initiated against you?
No, Lordship. Only thing, Lordship, I took leave and thereafter I was not allowed to join the service.
What is the stand of the government?
So the stand of the government is that, Lordship,
No, we have filed affidavit. Lordship, kindly see, he filed an additional affidavit. Additional affidavit, he has annexed certain documents whereby his service was extended. That means he was a malot daily wage earner. In a malot, we have seen 2 years, after 3 years, he was engaged. He was a casual worker, malot. So here, page 61, library, he was, period is extended, his period of 1/9/2021 to 30th November 2021. Thereafter, no extension. Again, on 2023 September to February 2004. And there was no extension gap. Again, 2004 June to August 2004. This way, that way, Malar, he was casually attached with us office. He was not a regular employee of that office. And again on 2009, September to 12, 2009, he was extended. Therefore, I think again on Malot 1st January 2010 to 28 February 2010. And thereafter, no extension, I think. One is there up to 1/11/2010. This is his history, Malot, of service. He was purely casual employee, Malot. He was arrested by the police. As his casual employee, he was not allowed to resume his duty. Daily wage earner. His first appointment is his Malot Guwahati Baber Adek Dia Holsi Daijo Komoto Dinot Doinik.
But there must be some order that he is disengaged, not longer required.
But that is Malot, I don't know, but I don't have this
You have
instruction.
filed an affidavit. How can you say?
No, we have filed an affidavit, but the affidavit does not say that we have terminated him or
yes.
is that is Malot not there, Malot, in affidavit.
No, you read para 9 of your affidavit.
Para 9 says, my lord, reported a 15 Department state that since the petitioner was a masterable casual employee, he is liable to be dismissed without any notice.
Oh.
I think there may be notice dismissal order.
But then you have
No,
to
no.
serve him.
There is no listener. And Lordship, my few days back, Lordship, I gotten unofficial information, Lordship, my name has been put for regularization also. I am not very sure, Lordship.
Get sure.
Lordship, the
Get your
no,
information.
Lordship, petitioner wanted to take the approach the office, but he was not was, he was not disclosed about any fact, Lordship. He was not. I don't know why, Lordship, but the petitioner is not allowed to enter on the office.
Lord, give me 1 week time, let me have the status. What happened actually, my lord?
And for a moment, Lordship, my the respondent also paid my arrears salaries also, Lordship. Lordship, annexure 16, page 80 of my additional affidavit, Lordship.
Since when have you not been allowed to work?
Lordship, last
2022.
to 2023, I suppose, Lordship, yes.
You bail on
22, Lordship.
22,
2022.
March 22.
I have rendered service, Lordship, more than 30 years, Lordship.
More than
More than 30. Am I almost more than almost 30 years, Lordship?
30 years.
Yes. 29 years, 7 months, 12 days.
But
Till the date of lodging of FIR. also.
But his documents annexed here with money does not say he is continuous service in 30 years.
That
He was
Lordship-
Wait,
4
your
years gap.
affidavit doesn't disclose anything.
Yes, Lordship.
But he
He
is
was a master role employee only.
yes.
Yes, Lordship.
He is liable to be dismissed without notice. What is this?
That is the ballot, whether that dismiss order pass or not, I don't know. Ballot. So let me have this ballot present status of this matter ballot from the Director of Campaign Affairs.
After filing affidavit.
Yes, ballot, because the affidavit does not clearly says, ballot,
All right, you get it on by 9 December. We want to
yes,
have all your instructions.
yes, sir.
Third counsel for parties, this writ petition is filed by the petitioner who was appointed as a master role worker under the Department of Culture,
Cultural
Yes, sir.
Affairs.
Cultural Affairs. And was allowed Cultural Affairs and appointed as a library attendant at Jyoti Bharati in Tejpur with effect from 2003-1992. So the appointment order was issued on 16th of March 1992. So the appointment order reflects that he'll receive a daily allowance of rupees 25 only per day for each work. And the order is temporary. And this order may be cancelled without giving any prior notice. Petitioners thereafter joined in his place of in his post pursuant to the order of appointment. So petitioner filed. Petitioner continued his services. Stop, however, on the basis of an FIR which was lodged against his nephew.
Against the petitioner also, but petitioner also filed FIR also. The counter.
Against the petitioner, he was taken into custody, but subsequently released on bail. However, when the petitioner reported back for duty, he was not allowed to join. And being aggrieved, he has approached this court. Whereas the respondents have filed an affidavit which reflects that, which does not dispute the averments made in the writ petition that the petitioner was appointed as a master role worker. However, there is no averment as to the status of the petitioner, as to why he was not allowed to join in his services, or whether he has been terminated. Stop. There are Mr. T.C. Sutia, learned government advocate on the other end, submits that he would like to complete these instructions and place it before the court in the next day, as agreed to, placed again on 9th of December.
Deeply, bro.
Others.
Five and six.
Item five is in respect of head pharmacist and item 6 is in respect of pharmacist, my lord. Before this honorable court, they are praying for the pay structure which is already been recommended by the commission. But till date not finalized. Two affidavits have come, one from the finance department. The finance department also agreed to the provision of the commission's recommendation. It is, they said, yes, it is correct, as the petitioners are saying it should have been done. The same, again, the health department also says the same thing, that as per the recommendation, it should have been done. But till date, nothing has been done. This is the case before my lord. And on one occasion, they said the proposal, the health is saying that in affidavit only, that is, if your lordship looks at page, paragraph 8, page 92. My lord, I'd like to bring your lordship attention to page 91 first, my lord, of affidavit of the respondent number 2.
Which
that is
matter?
Item 5.
There is no 91 here.
No, that is the affidavit.
6382.
6382.
Yes, 6382.
Page 86 onward, my lord.
Okay, 86 on, yes.
So I'll come to page 91 directly, my lord. My lord got it, but.
Yes.
So, my lord, the first thing that is that ROP 2017 and recommendation. If your lordship looks at that ROP 2017 is PV2 is given, ultimately recommended PV3 in respect of head pharmacist. And in respect of pharmacist, my lord, last line, the scale is given with GP as grade pay as 7,400, but next page, the recommendation is, my lord, with grade pay of 8,700. So that is admitted. Now the page 8, para 8, my lord, a small para, may I read it, my lord? That it is highlighted that the commission recommended payment to an GP of 330 in respect of pharmacist B.Pharm degree holders under the earlier ROP 2010 and as per ROP 2017. The deponent begs to submit that it is mentioned in the writ petition that the commission recommended the pay band 3 and GP of 4,200 in respect of head pharmacist under the earlier ROP 2010 as per resolution of the report of the 7th pay and productivity pay commission and the report of the committee highlighted in the beginning of ROP 2017 clause so and so. As regards the above, the directorate has already submitted proposal to the government which is under process for consideration of the government. I think that this part will highlight in my lord's last order, my lord. So both the cases are stuck with this, my lord. I think if I remember correctly, my lord has asked the asked them to get the instruction as to what happened to the proposal.
Revised proposal.
Yes, my lord. There are two orders.
Yes, Mr. Gugoi. Revised proposal.
My lord, here in page 80, the lordship see, my lord.
80.
It is part of the affidavit filed by the finance department.
Yes.
After, my lord,
considering everything from para 4, page 77. In para, page 80, the last para, it has been stated that in view of the above, Health Department was requested to reorganize the service as per recommendation of the APC 994 and amend the service rule and then resubmit with financial implication by the endorsement letter so and so. Well, that has not been submitted till date. Lordship will find, my lord, in page 81, last line of the para, since then no proposal has been received in the finance PRU department.
No, but why is the service rule required to be amended? Or implemented?
Because, my lord, the nomenclatures were not there, my lord, in 1994.
What nomenclature?
The nomenclature of, my lord,
Senior pharmacist.
senior pharmacist, yes. Lordship will find it, my lord, page 77, para 4 onwards. Lordship will see, my lord, it says that, my lord, there is no matriculate trained pharmacist in the grade pay of rupees 2,400, revised 6,200. And as such, this post should be abolished. The diploma holder pharmacist on promotion should get a grade pay of rupees 3,300 instead of 3,100 at present. Further, the commission recommended that B Pharm degree holders be given a grade pay of rupees 3,300, revised to 8,700 at entry level, and on their recommendation, the B Pharm degree holders will also be promoted as head pharmacists and given a grade pay of rupees 4,200, revised 9,100 in payment number 3. This The is Health and page Family Welfare Department, this was the recommendation, my lord, of the 7 pay commission. Now, Health Department then submitted proposal for upgradation of the following grade pay. Senior pharmacist from 9,100 to 9,400, head pharmacist with B Pharm from 9,100 to 9,400.
This is the, on the basis of the grade pay.
Yes, that is the, my lord, main difference, my lord.
Hmm.
And head pharmacist with diploma holders from 8,000 to 8,700 and pharmacist B Pharm from 7,600 to 8,700.
Hmm.
The recommendation of the 7 so and so may be summed up as follows. Well, the qualification has been mentioned. Pharmacists, diploma holders, its grade pay should be, my lord. Entry level should be 3,000, revised to 7,600. Thereafter, my lord, with B Pharm, 3,300 to 8,700. On promotion to the post of head pharmacist, diploma holders will get a grade pay of rupees 3,300, revised to 8,700. And from head pharmacist with B Pharm, they will get, my lord, 4,200 to 9,100. Thereafter, senior pharmacists.
No, under the rules at present, in so far as the writ petitioners are concerned,
My lord,
how are they placed?
but they are under, my lord, in the lower grade pay. In the pay grade number 2. Lord, you will see, my lord, page 79. The matter was examined in the finance PRU department. It was observed that there was no recommendation of the 7 pay commission regarding upgradation of the grade pay of senior pharmacists to 9,400. Then, my lord, it was further observed that the APC 1994 had, it is of pay commission of 1994, had recommended reorganization of the service in the following manner. Well, this has not been done, though it was recommended. So finance has now proposed that you first rectify this part, my lord, as per 1994, then, my lord, consequence will follow. And to submit a proposal in this regard, page 80, they have stated, my lord.
So why are you sitting over it?
No, my lord, here it says, my lord, in the affidavit filed by the Health Department, page 92. It's the affidavit, part of the affidavit filed by respondent number 2. Para 8, my lord. The last line says, as regards the above, the director has already submitted proposal to the government, which is under process for consideration of the government. And this was filed in February 25. So if a proposal, Lordship may direct the health to submit a proposal to the finance department. And they will consider, it will not be not only applicable to the petitioner, whatever be the decision, it will be applicable to all pharmacists
senior pharmacist and head pharmacist.
When was this proposal sent?
And
Well,
that
it was in the month of, I think, February or something like that.
no, that, my lord, date specifically has not been given, my lord, but statement is there. And it is very clear from the affidavit filed by the finance department. In August 24, that, my lord, no proposal has been received in the PRU department.
No proposal has been received in the,
Finance PRU department. PRU department, my lord, examines the various, my lord, pay scales and all.
to whom have they submitted the proposal?
To the government in the health and family welfare department.
That is your department you are representing.
No, that's why, my lord.
Uh,
So it's lying there.
In the
probably-
department you are
Yes,
talking.
interdepartmental lordship is, my lord, within a time frame, the lordship will direct consider, or it to place it before the
Yes.
next pay commission, my lord.
My lord, only thing, if your lordship permits me, my lord, 1 minute, would your lordship please come to page 78 once more?
Hmm.
My lord, this, as your lordship just posed a question like what is the difference we are getting? My lord, for pharmacist B farm in that table, my lord, if your lordship has seen revised 8,700,
Hmm.
we are getting 7,600. And then, my lord, for on promotion as a head pharmacist, revised is 9,100. My lord got it. We are getting only 8,000. But my lord, what about over one thing I didn't understand, my lord. In the name of senior pharmacist, everything is clumsy going on. But in the state of Assam, there is not even a single post or single appointment to the post of that senior pharmacist. This somehow came in between, don't know how. Even I tried to examine the matter, my lord, because it's pending for a long time. How did it come? But somewhere, my lord, this senior pharmacist has come, and now everything is based on the senior pharmacist nomenclature. But whereas in the state of Assam, there is not even a single post of senior pharmacist is absorbed or appointed, my lord. So as my friend suggested, my lord, with your lordship, with the time frame, my lord, considering both the affidavit and even considering my lord, representation, which is in detail, everything is covered as I covered in the.
Where is your
affidavit.
representation?
My lord, the representation is page 68 in Gunindra, in this case, which my lord is having, well, 6382. And my lord, one thing I have to inform this honorable court. This writ petitioner, he is the head pharmacist alone. He has already retired. Only thing that if the benefits is given because from ROP 17 it's coming up. If he gets the benefit, he will get it, my lord, during this pensioner period, my lord. Otherwise, he didn't enjoy it during his lifetime, service time. That is page 68, my lord, annexure 16. 11/7/2023.
It must have already been sent to the secretariat. You are addressing this representation to the director.
Yes, my lord.
The director must have forwarded the proposal to the secretary.
My lord, possibly, my lord. Nowadays,
Whatever justification is there, it is a department who will have to give the justification before the finance along with the proposal.
yes, that's true.
It is the department who will have to look into. My lord, here is a one more point it needs to be, my lord, addressed. That is that, my lord, the petitioner is a diploma holder otherwise.
No. No.
Initial appointment, my lord.
Initial. Bishop B.Com.
Thereafter- Subsequently, my lord, he got the, my lord, degree. And that is the,
No, I got the degree before ROP 17.
B farm degree, my lord.
Yes.
So, my lord, if he has got it, my lord, before the ROP of 2017, in that case, of course, it may be of some help to the petitioner.
Yes.
Otherwise, my lord, if he comes after, my lord, if attains that, my lord, particular degree, then it will be in the next pay commission, it will have
So
to.
whatever it is,
Otherwise, my lord, yes, in a broader aspect, my lord, it will be beneficial to all if at all it is considered, or if rejected, they will give the reasons, my lord.
heard council to publish. WPC
8/2.
6382 of 2023 filed by the petitioner who was serving as head pharmacist.
Yes, my lord.
And employed in under the Department of Health.
Yes, my lord.
Yes, and posted in various places. Stop. WPC 6146 of 23 filed by the petitioner who is, second writ petition is still employed,
Yes, yes.
serving as senior pharmacist,
My lord, senior pharmacist.
under the government also. Stop.
No, not senior pharmacist. No, this is the problem is senior pharmacist. It's a normal pharmacist.
This is the pharmacist. Stop. The, both the writ petitioners are aggrieved by the fact that the recommendation of the pay commission,
My lord, second writ petition is of 39 persons. That only mentioned.
39%.
Yes.
Second writ petition is filed by 39 writ petitioners who share a common cause of action as they are employed as pharmacists under the Department of Health and Family Welfare and posted in the various places across the state. So. The grievance of the petitioners are that in terms of the recommendation of the Assam Services Revision of Pay Rules, 2000 recommendation made under the Assam Services Revision of Pay Rules 2017. For higher pay scale, including grade pay of the senior of the what is the first person?
Head pharmacist.
Head pharmacist and pharmacist working in the state of Assam per month. These have not been given effect to. Stop. Learned counsel for the petitioners submits that for a head pharmacist, head pharmacist is a promotional post from the post of pharmacist, which is the entry level post. So, petitioner in WPC first writ petition has all the eligible criteria to be fulfilled. Has fulfilled all the eligible criteria, and therefore he meets the requirement for
Recommended pay
fulfilling
structure.
he meets the requirement for being granted the recommended pay scale. Stop. Likewise, petitioners in the second writ petition also fulfill the required parameters for being granted the recommended pay scale. Stop. However, the same has not been granted. Stop. Being aggrieved, the present writ petition has been filed. In both writ petitions, you have filed representations.
Yes, yes.
In both the writ petitions, the petitioners have filed representations before the appropriate authority, namely Director Health Service. However, their representations have not been redressed, and as a consequence thereof, they have approached this court. The Department of Health has filed their affidavit where they have accepted that the recommendations have been made under the ROP 2017. And there is a clear averment that the directorate, namely the Directorate of Health and Family Welfare, has already submitted proposals to the government, which is under process. Stop. The affidavits do not reveal that the claims made by the petitioners have been disputed by the respondent Health and Family Welfare Department. Stop. Better. Considering the submissions made and upon perusal of the readings available on record, it is seen that the following recommendations have been made in respect of the petitioner and petitioners in respect of the senior pharmacist.
No, no.
Pharmacist.
Head pharmacist and pharmacist.
Head pharmacist, then pharmacist. Insofar as the head pharmacist is concerned, the recommendations made are as under page number 89, extract. Insofar as pharmacist is concerned, you second rate petitioners fall under what? Diploma or degree?
No, degree, my lord.
All.
All. My lord, only thing, as your lordship mentioned, the head pharmacist and pharmacist in the initially, in bracket B Pharm, that will cover as degree, my lord. If your lordship could mention, my lord. B Pharm means degree.
All second rate petition, they were pharmacists within bracket B Pharma.
Even in the first also, it is required.
B
my lord.
Pharma.
Yes.
Both are B Pharma.
Yes, yes.
Okay. Then, so we are concerned with pharmacists B Pharma.
Yes, yes.
Not for diplomas.
No, no.
So far as the pharmacists B Pharmas are concerned, the recommendations made are as under page 91, 93. Yeah. So. There are in the affidavit filed by on behalf of the directorate, there is a clear evidence that the proposals to that effect has been submitted. These amendments are made in para 8 of the said affidavit. So, the representations stated to have been filed before the petitioners, before the department. Where is the representation?
My lord, in both the writ petitions, it is Annexure 16 dated 11/7/2023.
Both are filed on the same day.
Yes. And incidentally, both are Annexure 16. My lord.
These representations were filed in both the writ petitions before the Directorate of Health Service on 11/7/2023. Stop. The entire claim of the writ petitioners have been elaborated in the representation, giving the existing pay scale and the recommended pay scale. Stop. The representations have been filed requesting the department to implement the higher pay structure as recommended by the commission as per the report in the 7th Pay and Productivity Pay Commission. Stop. However, these representations.
The affidavit filed by the finance department also.
Yeah, that is important. My lord. Finance also did
It
not
has-
deny.
Finance has stated that, my lord.
Where is the finance affidavit?
Yes, it starts at page 75.
These representations have not been disputed. Yes. Yes, finance.
My lord, I'll rely on paragraph 4, page 78, 77.
77, my lord. Relevant will be page 80, last para.
That I keep in the affidavit filed by the finance department also. There is a clear averment that the Health and Family Welfare Department was requested to reorganize the service as per the recommendation of APC 1994 and amend the service rule and then resubmit the financial implications by the endorsement dated 31/08/2022. So, then come to the present.
My lord, page 70 would go to 78 would go to show that they accepted our claim, my lord, in that tabular form, my lord.
We have stated that.
Yes, no, only thing is the finance also agreed, my lord, to that recommendation.
Subject to the conditions.
Yes, my lord. Of senior pharmacist who is not in the picture. That's
My
what
lord,
I,
that acceptance will be finally considered, my lord, when the proposal is considered by the finance PRO department, my lord. That's why we have said, my lord, we are waiting for the proposal. Page 80. After resubmission with financial implications. Page 80 is paramount. They will take a call, my lord.
The council, it appears that the recommendation for the higher peak scale has not been disputed by the respondents. The health and family welfare on the other end has, as per the affidavit filed, has submitted their proposal to the government. However, from the affidavit, it is not clear whether these proposals have ultimately been placed before the finance department. Stop. The finance on the other end also does not dispute the recommendations in respect of head pharmacist and pharmacist, B pharma.
Yes, senior pharmacist.
Stop. However, in spite of the Health and Family Welfare Department being requested to submit the proposals with financial implications, the same has not been placed before the finance department for reasons best known to the Directorate of
No, the health
the
department.
Department of Health and
Yes.
Family Welfare. Under such circumstances, at this stage, there is no basis to be decided before this court in view of the clear acceptance by the respondent department in respect of the recommendations made by the finance department towards enhanced pay scale to be issued, to be granted. Enhanced pay scale recommended for head pharmacists and pharmacists B pharma. Under such circumstances, this court is of the view that the representations pending before the Directorate of Health and Family Welfare should be effectively disposed of by passing a speaking order. And further, the proposals necessary for implementations of the pay recommendations should be expeditiously submitted by the Department of Health and Family Welfare so that these recommendations can be implemented without any further delay. Stop. Needless to say that once the pay recommendations are made by the appropriate authority by constituting an expert body like the revision of pay commission, like the pay commission, and the same having been accepted by the, in principle, accepted by the Department of Health as well as by the finance department, there is no reason not to take appropriate steps for implementation of the same story. Let this order be carried out by the health department for disposal of the representation and further onward submission of the proposals to the finance department within a period of 60 days from the date of receipt of a certified copy of this order.
My lord, that examination will be done by the finance PRU department. It is there in the, my lord, ROP rule also, my lord. Whatever
But it
recommendation
has to be submitted.
by the health department, it will be submitted to the finance department, and finance PRU department will examine it, my lord.
No,
Not by expert body, my lord.
no, recommendation.
The recommendation of the expert,
Made
yes,
by the expert body.
regarding, my lord, reorganizing the post, my lord.
Recommendation of higher pay scale is done by the expert body only.
Yes, that
That is
part,
what we said.
my lord.
Disclose interim orders if any stands vacated.
My lord, only
Any-
one thing, as-
What else?
nothing, my lord.
Okay.
I'm deeply obliged. Only thing is that your lordship is given 60 days to the finance for the health to send the proposal. If they do it within 2 months, let the other side be 4 months, my lord. But it should be done.
Finance department will thereafter examine the proposal and pass appropriate orders
Lordship.
/ recommendations within a further period of 3 months thereafter.
Obliged.
Deeply obliged, my lord.
Yes.
My lord, we have received the record, my lord. So, my lord, next week, my lord, may fix, my lord.
This is for termination.
Lordship.
Termination.
Lordship.
Appeal filed.
Lordship, PD is complete, my lord, today.
No, appeal filed.
Appeal at phase 108, my lord. Appeal was also dismissed, my lord. Rejected.
All right. Mr. Mondo or M. Mondo for the petitioner, Mr. Dhar for PWD.
My lord.
The Mr. Dhar submits the records for the departmental proceedings have been received. Like to apprise the same. He would like to apprise himself of the same, and then thereafter address the court. Let the matter be therefore listed as agreed to on when.
My lord, any hearing, my lord. My lord's convenience.
Huh?
My lord's convenience, my lord.
Lordship, let it be on 2, my lord.
Huh?
2nd of December.
Will it be possible in December? Come in January.
Lordship,
We can give you, say, because 15, 16 is the last day, last week.
yes.
So we have the first week and the second week. You tell us when, fourth,
Fourth, my lord, already 2 matters got fixed, my lord.
see. Only 2 matters,
No, my lord, for hearing and
only 2 matters.
2 matters. My lord, rest I will have, my lord, backlogs, my lord.
You only have to apprise us with the records, rest we'll do, handle it.
Yes, my lord.
4th
4th
December.
Lordship.
তেওঁ আমি 1টা বজাত আহি পেলাই আপুনি ক'ব যে proceeding ৰ report টো আমি next পাৰিম মই বিচাৰিম আপুনি বিচাৰিব কাৰণে যদি কিবা clarification কিবা difficulty দেখিলে আৰু আপোনাক দেখুৱাই দিব জাষ্ট মোক খবৰটো লাগে আপুনি পাই এই ফাইলটোত বেলেগ ফাইলত আছে এইটো বেলেগত এইটো ফাইলত আছে এই খবৰটো লাগে Yes.
May it please your lordship. My lord, in this matter, my lord, petitioner agreed by the findings of the disciplinary authority as well as the appellate authority, my lord, and I'm being placed the compulsory retirement by imposing the
This is
major
what,
punishment.
compulsory retirement?
Yes, my lord. And here, my lord,
This will
admittedly,
require examination of records.
Yes, Lord.
Hearings.
required.
and record is
Have you filed an appeal?
yes, my lord.
Appeal
Against-
rejected.
Ejected.
What is your ground for challenge?
Yes, it is under challenge appellate authority, disciplinary
What is
authority.
your ground for challenge?
My lord, here 2 grounds you have taken, my lord. First of all, my lord, entire matter, my lord, inquiry officer, my lord, while no presenting officer appointed. And secondly, my lord, all the independent witness evidence as well as my reply as well as my objection, not even single whisper made so far as my evidence and reply is concerned. And independent witness will discuss all this, not even no allegations against me, my lord. Without considering all this aspect, my lord, overlooking this all this fact, disciplinary authority imposed me this major punishment, as the appellate authority also not discussed on this point. So non-appointment of presenting officer is vitiate the entire proceeding, my lord, and my determination is due on 29th February.
Where is the show cause?
Yes, my lord, at page 29, my lord, annexure 2. Recorded again. Like it. On 6 January 2022, my lord. And elaborately, I have given that meant accidental transmission of the video to that concerned officers, my lord, employee, stated in paragraph 3 and 4 of my reply, my lord.
You are employed as what?
At that moment, statistical assistant, my lord, in the CDPO Demoria ICTS project. And my reply at page 31 and extra 3, my lord. Paragraph 3 and 4 I have, in detail, I have stated, my lord. If a lordship will find in the imping orders, no discussion has been made so far as my reply is concerned. And altogether, 8 independent witnesses, all the omens, my lord, and there's no adverse evidence made against me, my lord. Though in the imping findings, it is held that in the office place, in the working place, I harassed. It is absolute silent on evidence, my lord. The wrong fact recorded.
This is this is under internal complaints committee inquiry.
No, Lordship, this is a departmental proceeding, Lordship. This is the findings of the department.
Right, get your records.
Yes.
Counsel for parties, since this is a case for challenging the departmental proceedings initiated against the petitioner as well as the imposition of punishment and the order and the order passed by the appellate authority confirming the order passed by the disciplinary authority. Let the records of the case be called for. Matter be listed for hearing in January
Lordship, January. Can be, Lordship.
27th.
27,
26 January, my lord. Can it be a little earlier, my lord?
What is the point?
Holidays,
You are going for a hearing matter, you'll have to be heard. Records will have to be heard.
yes.
List for hearing is ruled.
Deep love, is it?
Yes.
Then, my lord, CCTV today is the set for admission for admission, matter be admitted, my lord. So
We have admitted it.
yes, my lord. Deep love last.
May I please close?
Yes.
In this case, your lordship, the petitioner has put to challenge the disciplinary proceedings and also have a prayer for reinstatement in service. Your lordship. The facts in nutshell are like this, your lordship. The petitioner, your lordship, is working as a superintendent in Directorate of Tea Tribe and Adivasi Welfare, Assam, your lordship. Now, your lordship, while doing so, your lordship, he is superintendent, your lordship. Otherwise, he has nothing to do with the store, etc. But in 2021, when the director, your lordship, was shifted out, he handed over the keys to him, your lordship. It is completely and unofficially it was handed over to him. And he kept in the table, your lordship. Thereafter, your lordship, the times are going on, your lordship. And in fact, in this store, your lordship, there is around 97 mobiles, your lordship, which was, your lordship, purchased for distributing among people belonging to Tea Tribe communities, your lordship. Now, your lordship, when audit came, your lordship, audit find that 97 mobiles are missing, your lordship. Then, your lordship, inquiry was conducted, preliminary inquiry. Now, preliminary inquiry, your lordship, find that since I was the custodian, your lordship, therefore, I am responsible for that loss. And an FIR is lodged against me, your lordship, based on that, your lordship. Now, when FIR is lodged, your lordship, in the meanwhile, I obtained an interim order, your lordship, for bail. And then your lordship, police completed the investigation and filed charge sheet. And I was not, your lordship, named as an accused, your lordship, charge sheeted accused, your lordship.
They have found one casual employee who was working since 1996. He has stolen those phones. So now
There is no criminal proceeding against you.
no criminal proceeding. Be that as it may, Your Lordship, they have suspended me, Your Lordship, and in the meanwhile, disciplinary proceeding was also initiated by issuing show cause notice. I replied to that, Your Lordship. Thereafter, Your Lordship, during that, Your Lordship, they have, in the meanwhile, I came before this honorable court, Your Lordship, and during the pendency of this petition, Your Lordship, they have issued a show cause notice, Your Lordship, which I have annexed in an interlocutory application, Your Lordship. They have expanded Your Lordship, the scope of inquiry, Your Lordship. What is not there in the charge sheet, Your Lordship, that as one such aspect was also brought in, Your Lordship, through that notice, Your Lordship. Then I filed this interlocutory application. During the deliberation, Your Lordship, one aspect came to the notice of the honorable court that, Your Lordship, when charge sheet was issued, Your Lordship, when I was suspended and in the charge sheet was issued, there is a gap of around 4 months, Your Lordship. Now, going by that principle, Your Lordship, laid down in Ajay Kumar Chaudhary, Your Lordship, prior to 90 days, after 90 days, they have issued the charge sheet, Your Lordship. Therefore, I am entitled to, Your Lordship, my humble submission before this honor, I am entitled to, Your Lordship, the reinstatement in service. On that point, Your Lordship, the matter was there, Your Lordship. Today it is listed, Your Lordship, on his request, Your Lordship. Now, if Your
Now,
Lordship.
what is the status of the inquiry?
Inquiry, Your Lordship, first notice was issued, Your Lordship, and that notice, Your Lordship, when that notice was issued, as per the verbal observation of this honorable court, Your Lordship, we have filed a petition, Your Lordship, seeking exemption from appearance, Your Lordship, since that matter was taken up by the honorable court on that particular date.
In this writ petition, you are also challenging the departmental proceeding.
Proceeding, Your Lordship. Basically, Your Lordship, I am praying for, Your Lordship, reinstatement in service. Your Lordship. That's my
Departmental proceeding.
departmental proceeding. I am challenging, Your Lordship. That is also challenging, Your Lordship. But today, Your Lordship, my prayer will be for, Your Lordship, consideration of that suspension part, Your Lordship.
You are making an interim prayer.
Lordship, if Your Lordship. Or Your Lordship, if Your Lordship hears the entire matter, Your Lordship, that for that also I am ready, Your Lordship. Lordship. Your Lordship will kindly come to the writ petition first, Your
No,
Lordship.
firstly, tell us why you are challenging the departmental proceeding.
Departmental proceeding, the ground, Your Lordship, I am challenging, Your Lordship, that the whole departmental proceeding is based on, Your Lordship, was initiated on preliminary inquiry based on which FIR was lodged, Your Lordship. And FIR found me, Your Lordship, innocent, Your Lordship. The investigation found me innocent, Your Lordship. After investigation found me innocent, that I have no role at all in, Your Lordship, theft of these 97 mobile phones, Your Lordship. Then therefore the question of, Your Lordship, continuing with the disciplinary proceeding does not arise, Your Lordship. That's the basic premises on which I have put this disciplinary proceeding to challenge, Your Lordship. Now, Your Lordship, if Your Lordship sees the charge sheet, Your Lordship, which part of my affidavit in reply, Your Lordship will find that their entire case is based on that FIR, Your Lordship. Now that FIR has gone, Your Lordship. What remains therefore there, Your Lordship? That is what, Your Lordship,
These grounds you can urge before the departmental proceedings.
Departmental proceeding, I can urge those grounds before the departmental proceeding, but Your Lordship
It's a question of facts, evidence. You can take every ground before the departmental authorities.
No, that I can always take, Your Lordship. That's what has fallen from Your Lordship's mouth. But Your Lordship, the point is, Your Lordship, if the whole basis, Your Lordship, foundation of the proceeding goes, Your Lordship, whether it will be, Your Lordship, will it not be prejudicial, Your Lordship, for me, Your Lordship? Ultimately,
the show cause,
Your Lordship, will kindly come to affidavit in reply filed by me, Your Lordship. There's two show cause, Your Lordship. First show cause, Your Lordship, not in terms of Rule 9 of the Assam Discipline and Appeal Rules, Your Lordship. Your Lordship will kindly come to Your Lordship will kindly come to page 128. May I read, Your Lordship?
yes.
Show cause notice. You are hereby required to show cause under Rule 9 of Assam Service Discipline and Appeal Rules 1964, read with Article 311 of the Constitution of India. read with Rule 20 on Assam Service Pension Rules 1969 as to why any of the penalties prescribed in Rule 7 of the opposite rule should not be inflicted on you for the following charges based on the statement of allegation attached hereof. The Directorate of Tea Tribe and Adivasi Welfare Assam has purchased total 2,702 numbers of smartphones to provide smartphones to Lines Order in Tea Garden under the scheme of promotion of digital literacy and uses during the financial year in the year 2020-21. Out of these purchased smartphones, 2,570 numbers of smartphones were distributed to Lines Orders in various tea gardens during the year 2021. Remaining 132 numbers of smartphones were kept in the office building for contractual staff of Program Management Unit. Out of these remaining 132 numbers of smartphones kept in this office building, 35 numbers were kept in the almirah of the directorate and rest 97 numbers of smartphones were kept on the third floor of this office as per official record. Further, it is to be mentioned that during the visit of audit team from the Office of the Principal Accountant General Assam, Beltula, Guwahati 29 from 24th August 2024 to 10th October 2024. The audit team has conducted a physical verification of the stock of smartphones stored in this office building. However, during the physical verification, the audit team has not physically found the 97 numbers of smartphones kept in third floor in the entire premises of this building. Upon noticing of the same, the Directorate of Tea Tribe and Adivasi Welfare Assam has conducted an inquiry through the Joint Director of this Directorate. During this inquiry, Joint Director has found that the key of the lock of the museum building where these 97 numbers of smartphones were kept is with you. That is Sri Anil Kumar Deuri, Superintendent of Directorate since 19/5/2021. In the conclusion of the inquiry report submitted by the Joint Director, he has found that without breaking the lock and key of 97 numbers of smartphones are missing. And since Anil Kumar Deuri, Superintendent, was the custodian of the store, hence Anil Kumar Deuri is solely responsible for missing of these 97 numbers of smartphones. In view of the above, an FIR has been lodged by the undersigned at Birubari Police Outpost by letter number so-and-so, dated 17 December 2024, to conduct a proper investigation for finding out the same. That the Government order dated 3/2/2025 and instructed the Director Tea Tribe and Adivasi Welfare Assam to make necessary arrangement for issuance of suspension order and for initiation of disciplinary proceeding against you. That is Sri Anil Kumar Deuri, Superintendent of Office of the undersigned, as per relevant provisions of the concerned service rule and the Assam Service Discipline and Appeal Rules 1964. Accordingly, suspension order dated 19 February 2025 was issued and you were placed under suspension. In your above acts tantamount to gross misconduct and dereliction of the duty. List of documents and witnesses proposed to be relied on for proving this, your lordship. Then your lordship will kindly come to next page, your lordship, written statement. Written statement I have given, your lordship. Now, this was the allegation, your lordship.
Where is the written statement?
My written statement, your lordship. That immediately given.
It is not part of the.
That is not part of the record, your lordship. But your lordship, in the as part of your lordship, first so cause your lordship, I have replied. That was the reply.
That was dropped and fresh so cause was.
No, your lordship, that was not dropped. What has happened, your lordship? That is the initial so cause, your lordship. That is not the. There was no statement of allegation. There is no list of documents. They are only so cause that why disciplinary proceeding under Rule 9 should not be initiated against me. To that, your lordship, I have replied, your lordship. That reply itself. That is part of the writ petition, your lordship. Your lordship will get it at page 41 of the writ petition, your lordship. Page 41. Your lordship.
Yes.
Regarding the keys, third paragraph onward, your lordship, regarding the keys to the museum hall situated on third floor, a set of keys including a key to museum hall was given to me informally by deed and Director Sri Meenakshi Dasnath, ACS, when she was transferred. This took place on 19/5/2021. It is important to note that at the time I was informed of the items.
You are the superintendent.
I am superintendent. I am not the
of the
custodian.
museum.
The office, your lordship, not the
Or the office.
office.
And these keys belong to?
It should be with the director, your lordship. When director was transferred, your lordship, no new director was there, your lordship. This is unofficially placed before me, your lordship. Now, your lordship will kindly see one letter, your lordship. That, what is it?
The purpose of giving you the keys is for you to assume the responsibility.
No, that is, your lordship, in my humble submission, that was not, I will show one letter, your lordship will find. Your lordship will kindly come to page 68. In 2025, I have handed over these. While doing so, your lordship, this was, they have acknowledged the receipt. Submission of 65 keys. As per your verbal instruction, the 65 keys that were kept informally on the table of accounts branch room, your lordship, I am submitting them to you, your lordship. It was, your lordship, never formally handed over to me, your lordship. And your lordship, from the preliminary inquiry itself, it becomes clear that various persons at various point of time has went to that, your lordship, taking the keys, your lordship. The preliminary inquiry itself reveals, your lordship. In spite of that, they have blamed me, your lordship, lost the FIR, your lordship. Had the police charge-sheeted me, your lordship, then matter would have been different, your lordship. Some kind of, your lordship, my connivance or, your lordship, conspiracy. As a conspiracy, I may come in, your lordship. But that was not there, your lordship. In spite of that, your lordship, whether, your lordship, the liability can be fastened on me or not.
But these you will have to take up before the authorities.
No, that I will, your lordship. That
You see, unless you say that these proceedings are unauthorized in the sense that the person who initiated not competent to be
no,
a
that is not there.
inquiry officer, no inquiry officer
Lordship.
appointed, or a witness, or inquiry officer is also a witness, or maybe no charge sheet, something very arbitrary.
That is there, your lordship.
On merits.
No, your lordship probably cannot enter, but your lordship will
No, it's
see.
not that we cannot enter, but we would not like to enter
Lordship.
because.
No, absolutely, your lordship. But one aspect, your lordship, will kindly note, your lordship, that if a criminal proceeding is pending against an delinquent, your lordship, and also your lordship, disciplinary proceeding, your lordship. Now, in that case, if criminal proceeding, your lordship, he is honorably acquitted of all the charges. Honorable Apex Court has also held that in that case, I am entitled to, your lordship.
Correct.
Now, here is a case, your lordship,
There
where
is no proceeding is against you.
that is what, your lordship, that they have, your lordship,
But is
initiated.
there a bar that the
No,
department proceeding?
your lordship, that there is no bar, your lordship. Bar, your lordship, as such is not there. But your lordship will kindly see that once, your lordship, if we
Mr. Pothagur, the problem is not that. Problem is that, see, this is not a case where you have been terminated
lordship, that is there, your lordship.
or your salary or everything has been stopped. You are still employed. This
Lordship.
is the proceeding which the department has initiated. You have your remedies of filing reply, going in appeal, whatever is there. It is also not a case, according to you, that these proceedings are totally unauthorized,
No, that is not there, your lordship.
or it is
That is
completely in conflict with the rules. Nothing like that. So it's a question of whether these allegations are able to be whether you are able to stand up to find a good defense for these allegations, and whether the authorities are convinced that yes, your explanation is sufficient. This is the only case, but whether we should substitute ourselves and examine whether on facts it is correct.
No, your lordship is not required to, your lordship,
No,
on facts. That's
then-
not my case. My case is that once the very foundation of your proceeding goes, your lordship, how can the superstructure stands over it, your lordship? It will automatically, your lordship, dismantle.
Let us go to that charge sheet. again.
Lordship.
This is not on the ground that we are proceeding because there is a FIR. This is on the basis of an inquiry report.
Lordship. And based on inquiry report, your lordship, they have lodged the FIR.
Hmm.
And your lordship will see the FIR, your lordship. There is specifically, they have named me in this FIR, your lordship.
Hmm.
That I am the responsible for all this. Based on. That FIR, your lordship, investigated. Police found nothing against me.
Because therefore, this explanation is still open to you.
No,
To
that,
be placed before the authorities concerned.
that your lordship is always there, your lordship.
No.
That will probably your lordship will not take away your lordship power under Article 226.
Certainly
your
not.
Lords.
But first thing is that we must know whether you have placed this material before the authorities, requiring them to decide on this matter.
Lords.
Or let us say they are in the process of conducting an inquiry, whether any orders have been passed.
And secondly, your lordship, that why my apprehension has come, your lordship will kindly take up the IA for a moment, one document, your lordship.
IA.
So, IA.
Yes.
IA, lordship.
IA for?
IA, your lordship, when this notice was issued, since I have prayed that since disciplinary proceeding under challenge, this should not be proceeded, your lordship. That was. Your lordship will kindly see. Page 18, your lordship. This is the notice. They have how they have expanded the scope of the inquiry, your lordship.
So then you have to allege mela fide.
Lord, no, your lordship will kindly see just for a moment, your lordship. The undersigned has been appointed as the inquiring officer in the proceedings you for your alleged in matter of missing 97 under your custody and non-maintenance of proper stock register, your lordship. That was not even part of the charge sheet, your lordship. They have automatically, your lordship, expanded the scope of the inquiry, your lordship. At that point of time,
Show us your reply.
lordship,
You have responded by filing a reply again.
lords,
Written statement.
lords,
You show us that.
lordship. And second part of my argument is regarding the suspension, your lordship, reinstatement, your lordship.
Ah.
That part, your lordship, it is apparent, your lordship, that the so cause was issued after 3 months, your lordship.
So that we'll come back.
Lords.
That-
Few minutes from your lordship. If your lordship takes up the IA, your lordship at page 25 of the IA, your lordship will kindly see the statement of allegation, your lordship. Your lordship will find, your lordship, first 2 paragraph narration of the fact, your lordship. Upon noticing the same, Directorate of Tea Tribe Assam Welfare Assam conducted an inquiry to the Joint Director of Directorate. During the inquiry, Joint Director has found that the key of the lock of the museum building where these 97 number smartphones are kept in with you, so and so, since 2021. In this conclusion of the inquiry report submitted by the Joint Director, he has found that without breaking the lock, key 97 smartphones are missing. And since Anil Kumar, the superintendent, was the custodian, hence Anil Kumar is solely responsible for the of these 97 number smartphones, which are government property, and are solely responsible for its custody. And next page, your lordship, in view of the above, an FIR has been lodged by undersigned at Birubari Police Output by letter number so and so, dated 17 December 2024, to conduct a proper investigation of the finding out the same. Your lordship will kindly see, your lordship, their entire case, your lordship, is dependent on this FIR, your lordship, this allegation.
No, but ultimately it all depends on the availability of proof substantiating these allegations,
Lordship.
which situation has not arrived as on date.
Lordship, my only prayer, your lordship, submission before this honorable court on that point is, your lordship, that continuation of this particular proceeding, in spite of the honorable not even finding anything by the criminal investigating team, your lordship, will be
You're not charged.
not charged, your lordship. Then therefore, your lordship, it will be oppressive in nature, your lordship. That's my submission before this honorable court. I am relying on one judgment, your lordship. Your lordship will kindly go through. This is where, your lordship, criminal acquittal was granted, but departmental proceeding he was found guilty, your lordship. GM Tonk, your lordship.
Tonk.
Tonk, your lordship. Para 20 and 30, these are the 2 paragraphs I am relying on, your lordship. It is thus seen that this is a case of no evidence. There is no iota of evidence against the appellant to hold that the appellant is guilty of having illegally accumulated excess income by way of gratification. The respondent failed to prove the charges level against the appellant. It is not a dispute that appellant, being public servant, used to submit his yearly property return relating to his movable and immovable property, and the appellant has also submitted his return to the return in the year 1975 showing his entire movable and immovable assets. No query whatsoever was ever raised about the movable and immovable assets of applicant. In fact, the respondent did not produce any evidence in support of bond or about the alleged charges level against the appellant. Likewise, in the criminal proceeding were initiated against the appellant for the alleged charges punishable
So,
under
but this is after the conclusion of the departmental proceeding.
even your departmental proceeding found him, your lordship, guilty.
That's right.
Then saying that principle, I am on the principle, not on your lordship facts, your lordship.
No, principle has to be understood on the facts of the
Yeah, absolutely, your
Now,
lordship,
in
on the
this
facts of the
tank-
case.
GM Tank's case,
Lordship,
there were two proceedings, identical charges, criminal, he has been acquitted. Therefore, the court found that the conclusions of the departmental proceeding without taking into consideration these findings in the criminal
lordship.
proceeding
Lordship.
is not correct. But
It's-
this is not an authority to say that where the employee is not charged, proceeding ought not to happen.
No, that is not the case, your lordship. My submission is also not there. My submission is that your departmental proceeding as well as in the criminal proceeding, you have set in motion.
That's right. But this is to be first considered by the departmental authority.
That is what your lordship, if you
You will have
go.
to raise this issue before the
No,
departmental authority.
your lordship, that part is always available to me.
No.
I have no
So
none.
if you have any authority to show that even in a case of this nature, that where the proceedings are criminal, where you are not charged, but the department proceeds that you are a charged employee and initiates a department.
No, department has not, department, that is why your lordship very carefully what they have done, they have not even referred to the charge sheet, your lordship. That's the point, your lordship will see. They have stopped where, your lordship, that we have lost an FIR against you, but not beyond that, your lordship.
You have to give an
Lord.
authority because otherwise.
My
at the
humble
threshold-
submission-
At the threshold, set aside with an interference of a proceeding like this.
Lordship.
Because the authority is still seized of the matter.
Lords, that's,
Now the evidence is still there for the authority to consider. It is quite possible that the authority may agree with your submission.
lords, that is there, your lordship, may agree, your lordship, may not agree,
May
your
not
lordship,
agree.
that's a different matter altogether.
Right.
It is for their wisdom, your lordship. But the fact remains, your lordship, my submission is that based on the same allegations, once criminal proceeding has been dropped, you are going ahead with the disciplinary proceeding, that itself shows that there is something more than what your lordship meets the eye, your
Then
lordship.
you will have to.
And that is why I am relying on this, your lordship.
That will have to allege malafide
Lordship,
specifically.
lords. Sometimes, your lordship, malafide can be smelt, your lordship,
Yeah,
from the
inferred, yes.
actions, your
Yes, but then you'll have to urge this
lordship,
specifically.
lordship.
That there is malice.
20 and 30, I am relying on your
Judgments-
lordship, I
all
leave
these
it to
judgments are testing the conclusions of the departmental authority
lordship.
vis-a-vis the criminal proceedings.
With utmost respect, your lordship, if your lordship, last line of 20, your lordship will see
Hmm.
that it says it was submitted by the Department of Proceeding and Criminal Cases based on
Last line of 20.
20, last 4 lines, your lordship. It
Yes.
was submitted that the department proceedings and the criminal proceedings are based on the identical similar set of facts and evidence. The appellant has been honorably acquitted by the competent court on the same facts and evidence, witnesses, and therefore the dismissal order based on the same sets of facts and evidence. That is the most important part.
Here it is not the case.
Lordship, no, that is what your lordship, because your lordship, to that extent, it has not even gone there. Here is a case where your lordship, the police has found prima facie material and then proceeded against in any criminal proceeding.
So therefore,
In my case, your lordship, there is not even prima facie material, your lordship, to charge
therefore,
me.
you will have to allege malafide.
Lord, that malafide, apart from the malafide,
Yes,
even
some malice against.
even if I don't you see, your lordship, no alleged malafide, your lordship, even then it will be oppressive in nature, your lordship. And 30, your lordship, will kindly just
Something more you'll have to find out and in support of your
No, your lordship, so far as this part is concerned, this is much my argument. I leave it to your lordships.
This
Ultimately,
is
your
exactly what we don't want.
lordship.
Don't leave.
Now, your
uh,
lordship will have to decide.
No, don't leave.
My
it to us.
argument is
We'll
this.
decide once you raise the argument.
Lordship.
You see, you're trying to rely on this
Lordship.
case, but the facts are different. Here in a case where you are challenging at the threshold.
Lordship.
You're challenging at the threshold to say that, look here, you filed an FIR against me, even charge sheet has not been filed.
Lordship.
Yet you proceed.
Lordship.
Where is the law to say that you can't proceed?
Lordship, your lordship will
Now,
kindly see.
now, whether they are ultimately able to hold the charges against you and file the impose punishment is a different issue. It being at the stage of inquiry, it is open for you to raise all these defense in your favor. But unless perhaps you say that no, this is absolute malice. Otherwise, there is no reason for them to proceed against me.
I can understand what is fallen from your lordship's mouth, but your lordship, my
Because we'll have to answer that. We'll have to
lordship,
come to a conclusion. Yes, this is it's smacks of malice.
lordship.
There is something wrong which is not right.
No, even if it is not, it is just for your lordship to bring forth one argument, your lordship, that even if your lordship there is no malice, if your lordship finds that the manner in which they have proceeded, your lordship, they have proceeded is quite arbitrary in nature, your lordship. Since your lordship,
Right. So
that's then also your lordship can.
we don't
I have
find
not
any-
alleged
We don't find any arbitrary.
that
Arbitrary has to be vis-a-vis the rules
lordship will kindly
or some
see.
precedent.
No, vis-a-vis the rule and the action itself can be arbitrary on the face of it as a law laid down by the Honorable Apex Court, your lordship. That your lordship, if your lordship has not found it arbitrary, that's your lordship will
No.
ultimately.
It is not your case. You have not urged the case that the charges are not specific or definite.
No, that I cannot urge at this stage. That I will have to urge at your lordship stage when your lordship disciplinary proceeding will conclude. Those points I will raise
No,
before
you
it.
can.
Then.
I don't see any bar,
Sure.
but this is not your case.
No, that is not my case. My case simply is based on your lordship that once the very foundation of your proceeding against me goes when the criminal proceeding set in motion by you has found me, your lordship, innocent, your lordship. Therefore, you cannot proceed with me. You must have something more than that against me. And your lordship will kindly see they have not alleged there is in the statement of allegation. There is no allegation that I have, your lordship.
I would like to get into a debate with you,
Lordship.
but I cannot.
Lordship.
That is the reason I am not accepting your submission.
Lordship. That's your lordship. That my part is your lordship to place the facts.
No.
And
Because-
law I
Not
am.
because I disagree with you,
Lordship.
but the reasons why I disagree, these reasons I can't disclose. I can only disclose in my judgment.
That is what your lordship. That will be disclosed in the judgment. Your lordship.
So,
And second part is your lordship regarding suspension, your lordship. Now your lordship will kindly see the suspension part is your lordship. He was suspended on 31/2024. Or no?
no, suspension,
19
we can,
February
suspension we can independently deal with, provided you say that the challenge to the
No, there is both the prayers are there, your lordship.
disciplinary proceeding is not pressed
No, your
at
lordship.
this moment.
Lord,
At this moment.
lordship may kindly hear at least on the suspension part and rest your lordship. I will, your lordship, in the meantime, your lordship, so far as disciplinary proceeding part is concerned, I will. But your lordship, so far as suspension is concerned, your lordship will find that I was suspended on 19/2/2025 and charge sheet was, so cause was charge sheet was issued on 24/6/2025, your lordship. That is, your lordship, after 4 months. Now, that itself, your lordship, shows that I am entitled for reinstatement as per the law laid down by the Honorable Court, your lordship. This Honorable Court as well as the Apex Court, your lordship.
Apex Court did not lay down that law, with all respect. Ajay Chaudhary.
Lords, although Chaudhary and subsequent judgments by our
Our
High
court
Court.
has laid down, but
Lords,
Apex Court did not lay down.
Lords.
And Deepak Mali case is
Yes.
with regard to CCS rules,
Lordship.
where there is a specific rule. Where there is a specific rule. In here, the rules are different. Discipline and appeal rules are different. Rule 6.
Here, your lordship, that 3 months period is not there, your lordship.
Is not there.
Yeah. But your lordship,
And there is a power given them to put you under suspension on contemplation or pending.
lordship, that is.
That period for suspension is not defined, except read into it by judgment of a division bench of.
Lordship. In fact, your lordship, in one judgment, your lordship, Honorable Justice Michael, your lordship, Juthankwa, your lordship, he has, your lordship, this issue was raised, your lordship. He has dealt with this issue. Right now, I don't have, your lordship, that
Give it to
judgment.
us, we'll
If
examine it.
that your lordship will have to give me some time then, your lordship. But that judgment also looked into, and he has brought that issue, your lordship, dealt with that issue by bringing in, your lordship, the manual.
There is a division bench judgment on this issue.
Lordship. That is by the, that is there.
Sir. Suspension.
My lord has dealt with similar matter, my lord's order.
Ah.
I'm just placing it.
That is, your lordship, one by Honorable C.
Hafizur Rahman, that my lord's order, my lord. My lord has
Rafiqur-
taken everything in the account, then para 22 of Ajay Chaudhary, my lord. Where, my lord?
We'll come to you.
My lord,
We are
my
not completed with
my
you.
lord, my lord. I'm sorry, my lord.
No, no, you don't have to be sorry. You don't disclose your cards before you are asked to play.
My lord.
The more booklet আছে just.
One division bench judgment executed not made, your lords.
Suspension. I think it was by Justice, Chief Justice Sandeep Mehta and some other.
There was one judgment by the Honorable Justice.
It could be available here also. This is not under appeal.
As of now, my lord,
No appeal, no appeal.
this order is not under appeal, my lord.
It was in.
আসলে এটা মনে রাখছো post করে আপনাকে time on বিচারি না পাবো we'll continue the hearing, we'll get you all the judgments.
Lots.
Mr. Dhar,
Uh,
some Kuar or something, I forget the name of the judge. Some Kuar.
Okay. Hogono cases.
এটা এনেকুৱা spiral binding with ডাঙৰ হ'ব
মই
ইমান ডাঙৰ নহয় অলপ
এইটো মোৰ পেমেণ্ট আছে ডিভিজন বেঞ্চ সেইটো সবজেক্ট
ইমান ডাঙৰ নহয়
যিটো কথা মই এতিয়া মনত পেলাও
it seems what my lord is referring to the order, my lord. My senior friend was the counsel there. He doesn't remember the case,
that
but
your lordship division bench judgment, your lordship. On your lordship, the same point, your lordship.
Yes.
Yes, your lordship, I have asked.
Where reference was placed, I think, on Deepak Mali.
Lordship, I am asking him whether that is the case or not, because
Oh, it's heard counsel for parties. When are you ready to have the judgments again? For further hearing on.
on 1st of December, your lordship.
No, not first. Fourth is available.
Lords,
4th of December.
lords.
no,
Come back with your judgments.
my lord, fourth.
4th.
This morning, my lord has fixed another on fourth.
We'll all have four. Yes. Fourth of December.
Deeply obliged, Your Lordship.
Yes.
Make this lordship, my decision. A petition files against the minor sentence and minor dismissal from service minor. Petitioner is a BSF constable minor, the 38th battalion minor. He joined in the 2014 minor, thereafter he was put under suspension minor and
Where is the order of dismissal?
impugn order is minor. There is a provision for appeal minor, after that appellate order minor,
You have filed appeal.
appeal minor,
Appeal is
Appeal.
upheld, the dismissed.
dismiss minor. The appellate order is minor, that page, impugn order is page 72, annex 11.
So where is the order of dismissal?
Dismissal was minor,
I mean, the
Minor.
disciplinary authority.
minor. Annexure 9 minor, page 40. 48.
Is there any further appeal or revision, Mr. Goswami?
No, my lord.
Any further appeal revision? No.
No.
My lord, the basic, my lord, allegation against the my lord. The petitioner is that my lord. Some my lord amount has been my lord deposited in the account of his wife, my lord. Some by some unknown person, my lord. That has been my lord. It seems to be my lord. Prevention of Corruption Act, my lord, section 13 is attracted, my lord, and they have actually tried, my lord, by General Security Force Court, my lord. So General Security Force, there are two charges, my lord. One is violation of section 22E, my lord, and 46 of the BSF Act, my lord. So, my lord, the ground of my lord challenge before this honorable court is, my lord, while my lord proceeded against me, my lord, then as this my lord offense is under section 13, my lord. That's why, my lord, the prosecution is sanction is required under section 19, my lord. Because though he's a BSF personnel, my lord, but in case of my lord, except Army, Navy, and my lord Air, these three rest are required, my lord. So it's a paramilitary force, my lord, BSF, so it is required, my lord. So that is not there, my lord, before proceeding, my lord. And while, my lord, relying the, my lord, the bank statement, my lord, of the petitioner's account, my lord, wife's account, my lord, those are not exhibited according to the procedure prescribed by law, my lord. That is a being a electronic records or documents, my lord. Because as part of my lord Evidence Act, my lord, the section 64B is applicable and the Bankers of Evidence Act section 2A is applicable. That is not followed, my lord. Secondly, my lord, the document who has produced before the court, my lord, they have been asked as a, my lord, witness, not to bring the documents, my lord. As per the Evidence Act, my lord, witness may be two types, my lord. One, to bring the documents. If somebody brings the document, he cannot depose, my lord. Only said, this is the record I have brought from so. And second is, my lord, as a witness, my lord, he can depose what he knows about, against the, my lord. Case, my lord, against the accused person, my lord. That is, my lord, there, my lord. So only basic.
So essentially, he was punished for what? Overstaying?
No, my lord, the having illicitly enriched, my lord, enriched, my lord.
And
That
having two mobile phones.
mobile phone I have acquitted, my lord. There is no proof.
Okay.
Only that on that basis of the mobile, my lord. Though that is at that charges, my lord, I have got acquittal. They have seized my mobile, my lord, without any information. And that mobile also, my lord, they have not seized according to the procedure as per my lord Evidence Act, my lord, in the procedure, my lord. Because the mobile
They have not?
as per the procedure, my lord.
They have-
Just the commanding officer, when I returned from my availing the leave, my lord, asked me to give me that mobile.
I handed over the mobile. Then they have sent for FSL, my lord. Then some, my lord, WhatsApp message, and then they have to, my lord. Thereafter, they have, my lord, proceeded against me, my lord. So that seized my lord mobile, seizure of mobile, not according to the law, my lord. Either, my lord, there must be an allegation prior to, my lord, proceeded, my lord. The GSF trial, my lord, proceeded without any, my lord, complaint or whatever it is, my lord. Maybe GD&T also. They should put have in the record, my lord. This person is found to be illegally enriched. So there must be some record, whatever it is in the record, not as like a police station, my lord. So they also used to put GD&T, my lord. So there is no seizure, my lord. After, my lord, they have, my lord, the FSL report. On the basis of FSL report, the officer has directed to, my lord, code of inquiry, my lord. That is by SCI, Space Staff Code of Inquiry. There is a like, my lord, investigation, my lord. After completion of that, my lord, that is forwarded to the commandant, not my commandant, assistant, additional, my lord, DGP. So he approved, my lord, he should be tried, my lord. Accordingly, RO have been asked to, my lord, record of evidence, my lord. So in the record of evidence, my lord, they have 3 times recorded, my lord. That too, there is no order. First, they have recorded that they have again said that you record again. Again, my lord, additional. So 2 times they have recorded the same person, my lord. So this is not, my lord, prohibited by law, my lord. Once you have recorded, you cannot treat the person, my lord, 2 times the same person give a statement before the, my lord, authority, my lord. This is our, my lord, ground of basic silence of the impugned judgment, my lord. And I am in jail, my lord, last now, my lord, 2 years, 2 months, near about 6 days, my lord. So my sentence is for 4 years, my lord. There is a prayer for bail also, my lord. Lordship may admit the matter fixed before hearing, my lord. Consider the bail, my lord. And, my lord, the GSF trial proceeding also required, my lord, for the
Keep
final
bail.
hearing.
You have filed a separate application.
My lord, prayer in the petition itself, my lord, interim, not separate, my lord. If it is a writ petition, my lord, this separate petition may not be required, my lord.
We'll try to give you an early hearing. The records are there.
We filed a detailed affidavit in this
The records will be necessary.
My lord, the
And
record.
then the records are in vernacular, then you'll have to get it
Oh,
translated.
my lord, actually, this is the record. They have provided 1 copy to me. The origin is with them. But this is the whole trial proceeding, my lord. Whatever they have recorded, my lord, what is the final finding, they have not given to us. Only, my lord, dismissal part. Everything is here, my lord.
Where is
That
the
record is required.
finding?
I'll bring the original report, my lord, in the meantime.
This is
Another
the date
another
of the
aspect of the
proceeding,
matter,
my
my lord, is as regard the contestation made by the petitioner regarding that sanction. Well, it is not required. Well, I just obtained the instruction other day that the same query was put before the court. The flag mark portion, my lord, the authority is entrusted to proceed against me. And my query is there, first page, my lord. Then the answer to that query regarding BSF Act and Rule is proceeding is under that my lord, General Security Code, my lord. Then this is not required.
Yes.
This is subject to section 46 of the BSF, civil offense, my lord. If it is a within the, my lord, offense, my lord, other, that is, my lord, not required. But it is a civil offense, my lord. They have said 46, the BSF. It is a civil offense. So the, my lord, Prevention of Corruption Act, it not related with, my lord, discharging official duty, my lord. Otherwise, those are, my lord, no sanction is required. If I have committed some during the, my lord, but it is a civil offense because it is, that's why that is prosecution sanction
But it
is
is not
required.
in connection with discharging your official duties, assuming.
That is true, my lord.
then-
Instruction, it is the official duty, my lord. But it is because the allegation is that, my lord, in my wife accounts, my lord, some amount has been deposited, has been, my lord, said there is no answer, according to them. It is the illegal gratification or whatever it is by illegally enriching myself, my lord. So that's why it is a civil offense, not related to the BSF, my lord.
Parties admit matter be listed for hearing in the month of January. the relevant records containing the regarding the disciplinary proceedings. The call for the records must contain the inquiry report
My lord,
list accordingly.
to inquire not trial, my lord. GSF proceeding, my lord, the trial report.
General Court of Inquiry, my lord.
General Court of Inquiry,
Uh,
GCE.
My lord, General Security Force, my lord,
Security Force, Court.
Call for
Court
the records
proceeding.
of the General Security Force
Force Court proceeding.
or court proceedings in connection with this matter. Yes,
No, that my bail clear, my lord.
bail will consider.
Because that will be
Later.
fixed, my lord. Otherwise, my lord, almost 2 years, 2 months. My sentence is only for 4 years, my lord. They will get some kind of, my lord, deduction from the jail authority, my lord.
So we'll examine your prayer for
Well,
bail
any
will be
date
considered.
fixed?
My lord, that may be fixed, my lord. That
On the
what I
next date.
insist, my lord.
Then the matter is called. 29th January.
High level.
I'll
Yes.
Lordship, in this case, Lordship, the petitioner was removed from his service. And Lordship, thereafter petitioner preferred and also appeal. The petitioner is not aware of the outcome of the appeal. But from the affidavit filed by the respondent authorities, Lordship, Lordship may peruse page 50 for a moment of the affidavit in opposition filed by the respondent, Lordship.
Yes.
Annexure 2, Lordship, in the third para, Lordship. The last paragraph, Lordship. Shall I read it, Lordship?
Yes.
Later, LK Gopal Sodhi of Nalbari students, DEF submitted a prayer before the Director General of Police Assam Guwahati to reinstate him in service. And the Deputy Inspector General of Police Assam was directed to review the order of removal of so-and-so of Nalbari in the capacity of appellate authority. Accordingly, the Deputy Inspector General of Police Assam reviewed and removal order as well as department proceeding number so-and-so drawn up against so-and-so. The Deputy Inspector of Police Assam held pass an order by memo number so-and-so dated so-and-so for reinstating the applicant so-and-so. The applicant is reinstated in service. And the period of suspension from him is stated as on that, Lordship, my limited prayer will be I will be allowed to join in service, Lordship. I was not aware of the communication, and while filing this affidavit, Lordship,
You've been reinstated.
yes, I've been reinstated, but was very surprisingly, I am not allowed to join, Lordship. I have been reinstated on 17/8/2019, and Lordship, thereafter also I have submitted several representations before the respondent authorities. They are not allowing me to join, Lordship. You have to find my representations in my writ petition, Lordship. In a limited probably my area salary for the period for which they have treated me on service, that may be released, and I will immediately join in service, because Lordship, in the coming April, Lordship, I will be retiring, Lordship. If Lordship peruse my annexures of my writ petition, I have also filed RTI applications. And to that RTI, they have got reply, but in the reply, they have not supplied whether I have been reinstated or not. I am not aware whether what is the outcome of my appeal?
Yes, what has happened now?
No, Lordship, this is a clear, regarding the reinstate, we filed an affidavit, the annexer, it is categorically stated that it was reviewed and reinstated in service, Lordship. Now, Lordship, regarding his joining, Lordship.
His claim is that you are not allowed to join him. You allow him to join.
No, his prayer is not like, in the writ petition of the page 18, Lordship, there is no such type of prayer, Lordship, regarding the refusal of the joining by the department authority, Lordship.
The prayer is to, Lordship,
There is to reinstate in service.
No, already reinstate, Lordship.
That's right.
But
His claim is that he was not aware.
No, but
Lordship, kindly peruse page 30 for a moment, Lordship. Page 30 for a moment.
No.
Page 30, Lordship, of my writ petition, Lordship.
Yes.
This was an application, Lordship, submitted by the petitioner on 19/10/22 before the respondent to allow him to join. And thereafter, Lordship will find several communications from the department itself. They have sent communication
Yes.
Lordship, yes, Lordship. Lordship, page 18, kindly see, Lordship. This is his prayer, Lordship.
Hmm.
The, Lordship,
So we have seen the prayer, his
is
prayer is for
directed-
release of area salary
yes,
and to
only
reinstate
he
it.
is before this honorable court only for the area salary, Lordship, not the against the refusal of his joining,
But
Lordship.
the prayer is to reinstate him service.
No, the reinstate is not here, Lordship.
Yeah,
Yes, specific.
reinstate him service.
Page 18, yes. No, yes, now it is clear from the affidavit that he was reinstated,
No,
Lordship.
but he
Now-
claims
now-
that he is not
no,
allowed to join.
But no such type of evidence were given that his joining
We
letter
get
or.
the instructions and find out the why
Lordship,
he is not been allowed to
Lordship,
join. What is there to argue
but
here?
Lordship, before coming with the instruction, Lordship, I have to niche one his communication, Lordship, regarding he would like to.
Lordship, page 30, Lordship,
What is 30? Not
which is of 2022, and Lordship releases, then the subsequent, Lordship, the department, the SP Nalbari has asked the department to submit a detailed report also.
No, Lordship, if he know.
Lordship,
Page
kindly-
30, the prayer is that, Lordship. If he know about, if he knew about his reinstatement, Lordship.
I am not aware,
No,
that was
no,
a whole.
page
Why are
30.
you- Why are you unnecessarily arguing the matter, Mr. Counsel? His claim is that he wanted to be reinstated.
Lordship.
Your affidavit says he was already
Yes,
reinstated.
Lordship.
Now his claim is that he's not been allowed to join.
Yes.
Lordship,
So
I
we
will
have to
take the
get an
instruction.
instruction as
Lordship.
to whether,
Lordship.
what is the
Yes.
status, why is he not allowed to join?
Lordship,
That's all.
Lordship, this is limited.
And Lordship, there is a interim order from this honorable court that conditional, if they allows me to, I will join immediately, Lordship. Only I may be allowed to join my area salary.
What interim order is there?
Lordship, there is a order passed by on 26, whereby the pendency of the repetition shall not be barred. There is an observation, Lordship.
This is not a bar. This
No,
is-
yes, they can
No,
allow me to
I
join,
will
Lordship.
take the
That's
instruction,
instruction
Lordship.
we wanted
Yes,
to take.
Yes.
Lordship, I will take the instruction.
Heard counsel for parties, petitioner is agreed by the inaction of the respondent authorities in not permitting him to join in his services as a
Havildar, Lordship. At present, constable, Lordship.
constable
Before, in the office of SP in Nalbari.
in the office of the SP Nalbari. The petitioner had approached his court seeking a direction to the respondents to permit him to be reinstated, seeking a direction to the respondents to reinstate petitioner and release all his area salary. Stop during the pendency of the writ petition and in an affidavit filed by the respondent, by the senior superintendent, respondent number 5.
SP, Lordship, SP Nalbari.
It
SSP.
is seen that in the communication dated 8th of January 2024, which is enclosed as Annexure 2, page number 50 to the said affidavit, there is a reference to a communication issued by the Deputy Inspector General of Police within bracket CWR, bracket close Assam, dated 17/8/2019, whereby the petitioner was already reinstated in service and the period of suspension with effect from 19/5/2019 to 21/12/2014 was treated as on duty, and the period of removal from service with effect from 21/12/2014 till the date of rejoining in service was to be deemed to be a period in service and will be treated as leave without pay for all purposes. Stop. Whereas the counsel for the petitioner, upon the affidavit being filed by the respondent number 5, submits that although from the said affidavit it appears that the petitioner was reinstated, however, no specific order was served on him. And in fact, when the petitioner had approached the authorities to rejoin in his service, he was not permitted to do so. Para. The counsel for the respondents will obtain instructions as to whether the petitioner was reinstated in service, and if so, whether a copy of the order was issued on to the writ petitioner. And further, if the claims were made by the writ petitioner that in spite of approaching the authority, he was not permitted to join, is correct. Let these instructions be placed before the court. Again, on.
Lordship. Yes, yes, Lordship. 26. Okay, last of November, let's say any date, last week of November. It is December, first week of December, Lordship. Any date.
5th.
December. Lordship.
5th. List on 5th.
Of last.
For hearing, item 14.
Plus 14 is a peculiar issue because the petitioner is not in contact. He is not in contact with us. I've tried to contact him, but there's no instruction as of whatsoever means.
He is challenging what?
I'm challenging it, not dismissal, my lord. Initially, I was given compulsory retirement, my lord. I was removed from service, it was modified, my lord. Ground is, my lord, that I was found the influence of alcohol. My limited challenge is like that if you charge me with that alcohol, there should be some test. That those tests were not done. Blood test and urine test should be there. It has been held by in many forums, my lord. But now the issue is this, my lord, the person is enjoying his pension, and I don't have any contact with him. If he is happy and content with that, let the notice be sent to him, my lord.
Why should we send a notice? You send a notice to your client.
Yes, my lord. And another difficulty, my lord, I have not filed wakalatnama here. If something goes hereby there,
So
if he disowns me.
You don't know who is the counsel earlier.
My lord, earlier, my lord, different sets of counsel were there.
Who was the last counsel?
R. Mojumdar was there.
So there must be some other assisting counsel with him available.
One junior, he joined the Assam government service. Other two they are going blank.
Well, I heard Mr. D. Gogoi learned counsel, although as under appearance in the matter, he fairly submits that he is not holding to the wakalatnama, signed wakalatnama, as this brief was entrusted to him as the earlier counsel was elevated to the bench. Stop. MSA Gayan, learned CGC appears for the respondent. Mr. Gogoi has submitted that although he has made attempts, he has not been able to contact the writ petitioner. Therefore, he does not hold duly executed wakalatnama to represent the petitioner as on date. Stop. Under such circumstances, the registry is directed to issue notice to the petitioner intimating a change of counsel. Let this notice be issued by speed post in the address available with the registry. Matter be listed for orders again after 6 weeks.
Yes. In this case, Lordship, the petitioner was dismissed from service, Lordship. Challenging that, Lordship, this writ petition was filed. Affidavit in opposition already filed, and Lordship, we have preferred appeal that was also rejected, Lordship. Basing on an FIR, Lordship, the departmental proceeding was initiated. That is Annexure 1, page 19, Lordship. on the basis of a POXO case, Lordship. With due respect, it is stated that on last 27/7/19 in the morning about 8 AM, the below mentioned accused called my sister-in-law Tara Banu, 11 years, in his house for cleaning utensils and by closing the door forcibly raped her. It is therefore prayed to honor to investigate the matter, and accordingly, Lordship, one case was registered, last paragraph. Bongaigaon PS case number 550, 2019 under section 4 of POXO Act 2012. So my case is that, Lordship, the case is yet pending before the criminal court, and basing on this FIR, Lordship, the departmental proceeding was initiated and I was placed under suspension, page 23, annexure 2.
Where is the order or where are the findings of the inquiry officer?
Inquiry officer, Lordship, that is
Or let us have a look at the show cause.
first show cause, Lordship, that is page 24, annexure 3.
Hmm.
May I read the third paragraph? So, therefore, you are charged with gross immoral conduct, indiscipline, act, and dereliction of duty. The list of documents and witnesses proposed to be relied upon for proving these changes and charges and allegations are also enclosed herewith. You should submit your written statement in defense within 10 days from the date of receipt of this communication, provided you do not intend to inspect the documents which have relevance with the issue under inquiry. In case you intend to inspect those documents, you should write to the undersigned for the same within 7 days from the date of receipt of this communication and submit your explanation thereafter within 10 days from the date of completion of the inspection. Your written statement stating whether you desire to be heard in person should be submitted to the undersigned within the period specified above. In the disciplinary authority if the disciplinary authority decides to appoint an inquiry officer to inquire into the charges, you will be allowed to present your case if you so desire with the assistance of any other government servant approved by the disciplinary authority, but you will not be allowed to engage a legal practitioner for the purpose unless the person nominated by the disciplinary authority to present the case in support of the charges before the inquiry authority is a legal practitioner or unless disciplinary authority so permits. So list of documents were enclosed with page 25 and list of PWs also, Lordship. Inspector Jyoti Lahan was the PW1 and Munindra Narayan Das PW, Diwan Hormuz Ali in charge Vidyapur OP Lordship outpost, complainant and Tara Banu victim, and presenting officer was one SI UB Satyanath Kalita. Thereafter, statement of allegation, page 26. The same as on respect to the FIR on dealership. There was no other allegation, only in respect to the POXO case, the charge were framed. Then my reply, page 27.
What happened to the POXO case?
POXO case is still pending.
Still pending.
Yes, Lordship.
You're not discharged.
No,
Acquitted.
Lordship. Annexure 4, page 27, my first reply to the first show cause notice. With due respect and humble submission, I beg to state that the allegation against me is totally false and fabricated and who is imaginary in nature. It is true that one Musammad Sahida Khatun so-and-so lodged an FIR to the effect that I called Tara Banu, aged about 11 years, to my house for working utensils and forcefully committed rape on her. Subsequently, a case was registered against me by so-and-so. It is mentioned here that the whole story of the FIR is totally false and fabricated, and I am completely innocent for alleged offense made against me, and therefore the show cause letter served upon me is liable to be dismissed and thereby released from all the charges framed upon me. Then the inquiry report was submitted, annexure 5, page 28. During this process, 2 times present inquiry officer was changed, and the third inquiry officer, Mrs. Luna Sonwal, submitted this report. Last paragraph, Lordship. Accordingly, the first show cause notice under section 65 of Assam Police Act 2007 read with Rule 66 of the Assam Police Manual Part 3, Article 311 of the Constitution of India and Rule 7 of Assam Services Discipline and Appeal Rules 1964 was issued and served to the delinquent by memo number so-and-so. He submitted his first show cause reply on 25/11/2019. The disciplinary authority, after perusing the written explanation of the delinquent, was not satisfied and appointed Sri Makhan Bora APS, the then Deputy SP Bongaigaon, as inquiry officer by memo number so-and-so. Then the DP file was endorsed to Sri Pankaj Kakoti APS, the then additional SP headquarter Bongaigaon, as inquiry officer. But after district transfer of the earlier inquiry officer Sri Makhan Bora APS by so but after district transfer of earlier inquiry officer Sri Makhan Bora, hardly the DP file was endorsed to me as inquiry officer to inquire into the allegation by memo number so-and-so, and accordingly I had received the DP file number 6/19 containing from page number 1 to page number 30 along with note sheet page number 1 to 5 and other relevant documents on 7/10/2021 from the Reserve Officer, Police Reserve Bongaigaon, white number so-and-so, to commence the inquiry. During my inquiry, I have examined the listed prosecution witnesses and their statements were recorded accordingly. During examination of the prosecution witnesses, I offered them to examine the copies of relevant documents to refresh their memories and confirm accuracy, veracity, and authenticity. The delinquent was also given a chance to adduce defense witnesses, if any, but the delinquent denied. So, Lordship, pausing here for a moment, Lordship, no chance to cross-examine the witnesses were given to the delinquent.
You know, this is exactly what is stated in the inquiry, that you are given the opportunity, but he has nothing to say.
No, given to opportunity to cross-examine, it is not written, Lordship.
It is page 33.
But Lordship, in fact, there was no chance given to
No,
the.
to see page 33.
Under the above facts and circumstances, Lordship. That
Para
is,
7.
before that, Lordship, para 7, further UBC 163 Abdul Razak Mandal was released from judicial custody on bail and revoked from suspension. Currently, he is deported to the so-and-so. Later, for performing duty with the IGP Assam Bongaigaon. During inquiry, the charged person was given chances for cross-examination, but he has nothing to say as he had already given his statement to the previous inquiry officer. So only defense was given to the inquiry officer, but it is the case of the petitioner that he was never given any chance.
Did you raise it before the appellate authority?
Yes, that I have taken that ground. In second show cause notice, I have stated that there was no prima facie case in the FIR. As the medical report, we have also enclosed with the second show cause notice.
Medical report of?
The victim guard, page 36, annexure 7. Had written a case of Lordship forceful rape, there would have been some injury mark on the Lordship sexual part of the victim. But in the medical report clearly stated that no injury mark, last paragraph, Lordship. In fact, there was a dispute regarding rent regarding with the complainant, this petitioner, Lordship. So that FIR was filed, Lordship. In medical report also indicates that there was no such incident happened. We have enclosed this medical report along with my second show cause reply. Even then, Lordship, that was not conducted.
When was it conducted, medical examination?
Page 37 is the original. I have given the type copy before civil hospital.
Please see the opinion given, page 38. Opinion of the doctor.
No opinion can be given, could not be ascertained whether she was raped or not.
It's not an opinion.
Yes, Lordship, but the medical report says there was no injury mark.
That is not an opinion. The doctor says we can't give you an opinion.
Lordship, when
You
there's-
can pick up one finding from the medical report to say.
Had it been a case of forceful rape, Lordship, there would have been some injury on the.
We are not technical persons. We are referring to a medical report relied on by you. Where the opinion is very clear that we can't give you an opinion, whatever that means.
Only lordship, as there was no proof of rape, lordship, that opinion was
On
given.
what basis?
Lordship.
Medical report.
Lordship.
So the
medical-
doctor can't give you an opinion whether it was committed or not. How can you rely on it? How can the authorities rely on it?
Lordship.
You are relying on the some part.
No, the entire report I am relying, lordship, that Annex
Then
7
you live into the opinion. What is the ultimate opinion?
opinion, they accepted that lordship, as there was no such mark, so they cannot opine that it was happened or not, lordship.
Then the opinion should have been that there is no indication of forceful entry or rape.
Lordship.
That is not there.
It mentioned that there could not be ascertained whether she was raped or not.
Then
So before that, you were to, coming from the starting history, the victim was well oriented, so and so, so and so. Secondary section, sex character developed, breasts were developed by both. Location.
only
item zone-
164 statement.
Yes, Lydia abrasion marks seen over the chest, upper part of the sides. So what more evidence is required? ma'am?
Where?
The first part, lordship, history part.
History part is.
History part.
Yes. The doctor's report.
That is, the victim girl was well oriented to time, place, and person. She gives the forceful.
See, the incident happened on 27/7
Yes.
at 8 AM. Medical report is on 1/8/19.
Lordship, FIR was also lost after.
That this is an impugn order, your lordship. Only my contention is that I will just highlight this, your lordship, as they have highlighted also in the impugn order, page number 56. Your termination from the service by way of dismissal from service under rule is because I have been terminated from the service on dismissal of service. This is no, this one. This is purely overstay.
You received the show cause.
No, I have not received the show cause, your lordship.
You even did not receive.
Yes,
First, you were declared as a deserter.
deserter. I have declared as a deserter.
Prior to that, was any proceeding carried out?
No. There was subsequently after that there was a proceeding.
When you filed a writ petition in Shillong,
Repetition
I'm sorry,
in Manipur.
Manipur.
Because it was not maintainable. Then subsequently it was filed before the gate. Because of the want of the jurisdiction, I have come before your lordship. I have preferred the appeal, your lordship. Then subsequently review petition was also filed. That was rejected. Oh, yes, I wanted to bring, because as I was showing to your lordship, the page number 56, the impugn order, your lordship, I was pointing out that your termination from the service by way of dismissal from service with reference to 34/2019 under Rule 21 read with Rule 18 of SSB. Your lordship, I may allow to see the rule and the Rule 21 and the 18, your lordship.
Your Lordship, I may pass.
What rule? This SSB rule.
SSB, I think, what I think, SSB, that is of direct Simas, Sasastra Sima policy. What rules?
I have been terminated under the rule.
SSB rule 2009.
2009, Your Lordship.
Yes.
Sir, Your Lordship, Rule 21, termination of service of person other than officers on account of misconduct. When the purpose of the termination is service of the person is subject to the act of he shall given opportunity by the authorities competent to dismiss or remove from the subordinate matter subject to the sub rule so and so and so. So no opportunities was given to me, Your Lordship. I had not received the focus notice. At the same time, I was under emergency, medical emergency, as there was nothing such information was intimate to me. And secondly, Your Lordship, this misconduct, this is the termination was on base of my misconduct, and there is no such proof that impugn order has. My whole contention is that the whole exercise is done without going to any disciplinary proceeding, without laying any framing any charge, allegation, or list of witness, or no inquiry report was submitted so far.
All these notices were served.
Lordship,
Notices were served.
Lordship,
You have records for that.
all original records not clear, Lordship.
Then
But
you'll have to
from
go-
the very beginning, Lordship, notice was served.
you call
He-
for the records because you'll have to show us. His case is the case of ex parte proceeding.
Not expertise, Lordship. From the very beginning, no, the notice were issued to the petitioner,
Did he
Lordship.
appear in the proceedings?
In his, no, Lordship, he had not appeared.
Therefore, it is ex
Even the special messenger was sent to his home for with notice and court of inquiry reports, everything. But he did not participate even in the court of inquiry or in any of the proceeding, not join in his service,
You get the records,
Lordship.
show us how it was. One was by substituted service by publication in newspaper that we can find.
By newspaper, Lordship,
But
in a
the
newspaper, it was
first
published.
suppose notice, special messenger, how it was sent.
Lordship, may kindly
You have to
please.
show us from your records.
From Annexer A, Lordship, all the notices were annexed, Lordship, of our affidavit. The Annexer A is the office order by which he was granted 60 days earned leave
for his treatment, Lordship. And there is no documentary proof of his wife's Lordship pregnancy or any
This is a part of the writ petition.
part of the writ petition, but he never informed the authorities, Lordship, regarding any difficulties or sought for any extension of his leave period. This is the 60 days leave period. Lordship, first notice was issued on 28/12/2018, page 79, annexure B. May I read, Lordship? Whereas you did not report on your place of duty even after expiry of your sanction 60
So
days
we want to know how you have sent these notices.
by registered post, Lordship.
So what proof have you got?
Lordship, one annexure is
Was it
annexed.
delivered? Was it received? All these should be available in your records.
Lordship, para 17 of our affidavit, Lordship. Para 17.
It's a case of ex parte proceedings. He is given some materials to show that his wife was under treatment. And he is informed through the local police station.
But not the authorities. And during
What
this
is the
period, he
procedure?
never informed the authorities about his wife's ailment or sought for the extension of his leave period. There was no question of informing the local police, Lordship. He could have directly submit an application to the
Yeah.
authorities.
Why did you not inform your superiors?
Your Lordship, one officer have visited my house, Your Lordship, and
Yes.
I duly have informed. I have
No,
stated
no,
in
at
my
that-
petition.
At the time when your wife was indisposed.
That is the only minus point, Your Lordship, in this
What
case.
mind, that is the
Because
most-
only thing is that he was under pressure. He was not knowing what to do because whole thing was, he is a sole breadwinner and he is suffering from
He did
2000.
not know what to do, but he went to the police station asking them to send a report.
Because there was some notice was sent from the headquarters
So he
regarding
has
his.
received it.
Okay, so he has received and he have informed and he have submitted accordingly.
Uh,
And even the concerned officer has visited his house and he has explained also. I have stated in my petition.
Concerned officer. is-
From the SSB.
It was the messenger, Lordship, who served the
Special messenger.
piece of notice and
But
the
nothing such
report
has
of the
stated.
court of inquiry. Even after that, he did not join the duty.
Because I have said, I have submitted all my
And it is-
difficulties. And
Here
in that extent, Your Lordship, I will like to refer one judgment. Here it is
No,
clearly
no,
saying
no,
that.
judgment, we'll come to judgments later.
Okay.
First, let the facts be clear. Why do you straight away jump to judgments?
No, because there was no willful on my part, Your Lordship.
So
I was
how-
under the emergency medical.
How many,
circumstance.
what is the gap? What is the, how many
Gap
days
is-
were you absent?
It is little long, but it is, I can explain, Your Lordship.
How many days?
Total days will be around 129 days.
Days?
Let me break up, Your Lordship. That my child was admitted in the
Your child was released from the hospital after 1 month,
after 1.5 months.
1.5 months.
Yes.
Then after 1.5 months.
Subsequently, after that, he again re-admitted for some respiratory program.
But you
Then
did not
subsequent-
consider it
Yes,
appropriate
that
to
is only the-
inform your superiors.
But only thing is that nothing has considered in the dismissal of my, in the impugn order, Your Lordship.
What? Oh, nothing means?
Nothing was considered about my medical emergency.
He has not submitted even a
You
petition,
did not
Lordship,
submit
to
anything.
consider it.
How will they consider?
The authorities are not informed of any
How
of
will they
this.
consider? You did not submit anything. Perhaps you did not want to carry on.
No, now he is very young. He is just 43 years old. As on now, 2025, Your Lordship. He's joined his service in the year and he is somehow managing his, by this Hajira late day labor, he is somehow managing. He wants to join, He is competent, he is full,
Lordship, he was to join duty on 22/12/2018, whereas as per his statement, his son was born on 18/2/2019. In between, there is 2 months passed and he has not informed anything,
No,
neither
it is
joined
on
the duty.
his treatment also, his own treatment.
No,
Because
he want,
60 days was taken for my treatment only.
there is no
And
documentary.
Your Lordship, I have rendered 12 years service, Your Lordship. 2007, I have
No,
joined.
you may have rendered 12 years, 24 years, but it doesn't entitle you to disappear without leave.
Yes, that much I understand.
Then, what is you have been termed to be a deserter.
Deserter.
Yeah, initially.
So what procedure did you follow?
Followed Lordship, first apprehension role was, first the notice was issued in his home address, Lordship. When he did not join Lordship, apprehension role was issued to the local police twice. But local police did not take any action. Thereafter, court of inquiry was conducted. And after court of inquiry, he was declared deserter.
Where is the procedure for desertion?
Desertion, Lordship.
What procedure is laid out?
What's it? (74)(2) of SSB Act, Lordship.
74.
Lordship. Section 74. Two. 74 is inquiry into absence without leave. It is 2 is, Lordship, if the person declared absent does not afterward surrender or is not apprehended, he shall, for the purposes of this act, be deemed to be a deserter. (74)(1) is, Lordship, when any person subject to this act has been absent from duty without due authority for a period of 30 days, a court of inquiry shall, as soon as practicable, be appointed by such authority and in such manner as may be prescribed, and such court shall, on oath or affirmation administered in the prescribed manner, inquire in respect of the absence of the person and the deficiency.
What about Krishnakant Parmar? Sufficient cause? Was it examined?
Sufficient cause, Lordship, he has to submit something, Lordship, to examine whether there is any sufficient cause or not. He did not even communicate with the authorities or submitted any representation to examine.
So we need your record to tell us what steps you have taken in terms of see page number section 73, 72, 73.
Arrest by civil authority. Whenever any person.
Capture of deserters.
Yes.
You have
Civil police has not taken any action on the basis of the apprehension rule. Therefore, he was declared deserter. He did not join in the meantime, even after repeated issuance of notice. And in Annexure H, Lordship, he received the notice, which was sent through messenger, Lordship. Annexure H is page 126. And there is newspaper publication also. It was also published in newspaper. All the notice issued from the beginning, Lordship, it has been annexed in our affidavit. Even on 16/3/2019, before dismissal lordship at page 122, notice was issued directing him to assume his duty within 15 days after receiving this notice, failing which you shall be dismissed from service. Even after issuance of this notice, he did not join.
Then after he was declared deserter, what happened?
Again, lordship notice was issued to him.
Then
And then lordship
he
annexure,
finally turned up.
no, lordship, he received it. Annexure H, page 126.
Did he surrender before the?
No, no, no,
He did
lordship,
not.
no. Neither surrendered nor submitted any representation or communicated with the authorities. After his dismissal from service, he only filed a appeal.
No, but sufficient cause has to be examined.
So in order to examine the sufficient cause, it has to be before the authorities.
No, if the authority finally, because the authority sent requisition to the civil authorities.
Yes, lordship.
Now, after that, what steps were taken to pursue it?
Civil authority did not, lordship, return the apprehension rule, and therefore he was declared deserter after issuance of notice. Even after declaration of deserter, lordship, he was continuously issued notice to join the duties or he will be dismissed from service. But even after that, he did not join.
You are not challenging the order of desertion, Mr.
No, I have not challenged.
Then?
Direct, I have challenged the appeal. Session one, I have not challenged.
See, even if we accept your submissions, we allow the writ petition, we'll have to interfere with the
Desertion.
terminal
First
order, termination order. Desertion order will still remain. You'll still be labeled as a deserter, liable to be terminated or arrested. Unless you challenge it, they will not be confronted to. They should also be given an opportunity to answer. This is an ex parte decision.
Yes.
Now, this ex parte decision to be interfered with, that your grounds were, well, if not bona fide, to some extent may be accepted to be genuine, also does not help because you are already a deserter, which is not under challenge. Should you not challenge the deserter? Any other writ petition you file?
No, only this is.
Then what do you propose to do?
In that case, your lordship, so far the information is concerned, I have informed to the messenger, the concerned person.
Mr. Singh, please understand.
I understand. Your
There
lordship,
is an
that
order
so far-
passed by the authority
desertion.
holding you to be a deserter.
In that case, I may be allowed to amend.
That you did not file. Is there any order? Did you file any appeal against the desertion?
It was a subsequent order. That's what the earlier it was hand over from Manipur. They have not made the impugn of that disaster.
You complete your instructions and come back.
Because
Unless you, perhaps
because-
unless you challenge the order of desertion, we may not be able to help you much.
That's right.
In that case, your lordship, I may be allowed to amend the.
We'll give you some time to reflect, think
Reflect.
about it, matter the.
In the meantime, the record may be called for in the next year.
No, first you decide what you want to do. Why should we call for the records?
Yes, lordship.
Matter be listed on 9th of December. 9th. On the request made by Mr. NXC, Mr. MS. R. Devi, Leonard CBC appears for the respondent.
The petitioner is out of service since 1st of June 2022, my lord, by impound order protect Annexa 10, my lord. Operative portion of the impound order is at page 62, my lord. 62 of the writ petition. On the basis, may I read out?
Yes.
On the basis of the findings and discussions above and documents available on record, you have committed gross misconduct by misusing your official position as Lower Division Assistance of the Foreigners Tribunal, Second Morigaon, which is a quasi judicial body, and using the office computer and printer of the office of the Foreigners Tribunal, Second Morigaon, for manufacturing fake certificates of clearance from Foreigners Tribunal cases by taking gratification and issuing the certificates to persons to be used in connection with the updation of NRC, and hence you are not fit to serve in the Foreigners Tribunal. In exercise of power under clause 13 of the Assam Foreigners Tribunal's Establishment Ministerial Service Rule 2000 Order 2012, read with section 7 of the Assam Services Discipline and Appeal Rules 1964, you are dismissed from service with immediate effect. Thereafter, my lord, the petitioner has preferred an statutory appeal before the appellate authority, which has been taken 2 years time for disposal, and the same has been disposed of in the year 2024, which your lordship will find at Annexa 12, page 69. Page 69, Annexa 12. By upholding the order of the disciplinary authority.
Yes.
In this regard, my lord, the main contention of the present petitioner in this writ petition is that if your lordship would go to kindly see Annexa 7, page 52.
Did you participate in the inquiry?
Yes, my lord.
You
Kindly,
merely denied.
page 52. Page 52 was the show cause notice. On being receipt of the show cause notice, I have submitted my written explanation on Annexa 8 on within 10 days, 22nd of April 22. Which your lordship will find at page 53 to 56 onwards. And in my explanation, I have stated before the inquiry officer that Annexa 8, my lord, page 553. There are 3 charges framed against me at page 52, my lord. Number 1 is that while you were engaged in your official capacity, you were arrested by police. You are therefore charged with misconduct in the capacity of a public servant. Number 2, that you had indulged in any misdemeanors, hence you were therefore charged for abuse of your official position. Number 3, that you are a responsible citizen. You are supposed to uphold the law and pass such an act on your part is not desirable of a responsible citizen, hence you are discharged for discarding the law. These were the three charges against me, but this, if your lordship have perused the impugn order, and annexer, which is my dismissal order, annexer 10, which I have already read out before lordship at page 62, that the reason for dismissal of something different, not in terms of the charges framed against me. The reason assigned by the discipline authority is completely different. So, to that effect, I have clearly avoided all this.
Where is the order for dismissal?
Page 62. I have 62. I have read out
62.
Operative portion. Here, the conclusion of the disciplinary authority is completely different than, in comparison to the charges framed against me by the inquiry officer.
And what is the inquiry, the show cause again?
Show cause your lordship will find at page 52. 52, just three charges which I have already read out. 1, 2, 3. If your lordship will go through the inquiry report at page 76, my lord, annexer 15. Page 76.
Yes.
Page 76, it is the, I have obtained prior to dismissal, no inquiry report was furnished by the disciplinary authority to the present petitioner. And this inquiry report has been procured by the petitioner through an RTI application, which your lordship will find at annexer 15, page 76.
Yes.
In the from the RTI reply, it is came to my knowledge that at operative portion of this inquiry report is inquiry report, which has been forwarded to the disciplinary authority. Your lordship will find at page 78, which is a part of this letter. May I read out the operative portion?
Yes.
Inquiry report. With regard to inquiry report, my lord, in this, in his inquiry report, the inquiry officer, who is also a party to this petition, during the inquiry, Sri Pranab Kumar Bhattacharya, LDA, Furnace Tribunal 2nd Morigaon, was summoned for recording statement, and his statement state, number 1, the aforesaid show cause notice issued on so-and-so against him, which was duly served upon him on 18/4, which is my explanation, that the charge number 1 against him as reflected in the show cause notice dated so-and-so is absolutely false and not based on proper records. He denied he was arrested by police in his official capacity at the relevant time. That in reply to charge number 2, he begged to state that he has not indulged in any misdemeanors by abusing his official position as stated in the office notice dated 13/4/22. Number 4, that it is absolutely correct that being a responsible citizen, every citizen has some rights, liabilities, and duties to the laws of the land. But he vehemently denied their charge leveled against him in charge number 3, whereby he has charged that he has discarded the law. So all the charges have been denied, and in respect of the aforesaid charges, no documents nor any witnesses has been produced before the petitioner for to examine or cross-examination during the course of inquiry. And so far as most significantly, my lord, if I have submitted my explanation on 22nd of April, and this inquiry report is lordship will find the date 25th of April. 25th of April, the inquiry has been concluded, and is preferred, which has been sent to the disciplinary authority. I member Foreign Tribunal Morigaon.
Within 2 days, inquiry have been concluded, and the findings of the inquiry report is also paramount consideration of this honorable court in this case. Findings of the inquiry officer. SP Border Morigao has filed a report showing his findings of the fake documents relating to the following cases. Number one, this name of this person so and so have filed a report showing his findings of the fake documents related to the following cases. But whereas no charge sheet has been filed against the accused since last 3 years, and as per the order of the Honorable Guwahati High Court, he has joined the position. This is submitted for your information and necessary action. So there is no recommendation or any adverse material has been forwarded by the inquiry officer.
Where is that?
My lord,
Report,
this is the inquiry report,
page number 6.
78, ending, conclude, bottom of this.
78.
78 and 79 is the inquiry report, signed by the inquiry officer.
This
Who was working as the election officer of Morigao at that time. He was appointed as.
Then what is that page 59?
Page 59, I have to check. Page 59 is the impugned order, first impugned order which I am assailing. The order issued by the disciplinary authority, member of the tribunal.
This is the disciplinary authority. The inquiry report, where is the inquiry report?
Inquiry report which.
78.
78, yes.
Where is the inquiry, where are the records?
Records are here, Lordship.
Inquiry reports are there.
Yes, Lordship.
Proceedings?
Proceedings are not there, Lordship.
That
This
is
is
what
what
we-
I have been.
That is what we want to see.
Yes, Lordship. Only proceedings part is not there, but other things are
No,
there.
only
Lordship.
proceedings is required for it.
Lordship.
Nothing else.
Then it can be fixed on next Tuesday, Lordship. In the meantime, I shall call this one, Lordship.
You will have to see the proceedings.
Lordship. Next Tuesday, Lordship.
I heard counsel for parties, although the records, although the pleadings are exchanged and the learned counsel for the respondent submits that the records have been received, however, the relevant records containing the departmental proceedings relating to the initiated against the present petitioner are not available. Learned government advocate submits that she would like to requisition the same. She would like to call for the same, and therefore submits that the matter be listed after a week. So when?
Next Tuesday, Lordship, it can be.
Next Tuesday or 4th
4th. Okay, Lordship.
4th of December.
Published.
As agreed. Yes, Mr. Salman.
Met with lot. Here, my lord, the petitioner case is my lord for payment of salary of for 457 days, during which time he was on a treatment, and after medical examination and finding him fit, then he joined the duty. He is my lord, now Inspector Police in the retired in the APRO, Assam Police Radio Organization. Whatever I have explained from paragraph 4 onwards.
You're challenging the disciplinary proceedings.
I was challenging the disciplinary because I couldn't participate in the ex parte anyway. That was with 2 increments, my lord, not that much. But what I am on is that my absent period on medical health, after on duty I went ill because I was posted in such an area my lord, near Mizoram border, was a criminal infested area.
What is the conclusion of the disciplinary authority?
That they found me guilty and my lord punished with 2 stoppage increments. my lord.
This is not under challenge.
No, there is not. Annual increments were, my lord, cumulative effect was given.
And your prayer is to set aside the order, including entire departmental
Yes,
proceedings.
that is there. That is there. And primarily now I am left with my lord the primary prayer for payment of salary for they have declared me dash none. You also kindly see the annexer, C page 31. That's what I have challenged now.
31.
31, yes.
Hmm.
Annexer C man. They will regularize the period of my absence. Twenty-nine 7 2019 to 26 10 2020.
Hmm. You are challenging what exactly? What is your prayer? What is the prayer before the court? What is your prayer before the court?
No, I have challenged the dismissal proceeding also in entirety. But at the same time, my lord, because I was ill, they have said we have published in the paper. I was seriously ill in my place posting, then I shifted to medical college and other institutions of medical treatment. Then my brother became from Hailakandi, he took me there, he got me treated. There also I couldn't cure. There were many disease matters as per the findings of the medical board. Ultimately, when I recovered and medical board certified that now he is cured of all these are not there. So he is ready to fit to join the duty. So my claim is primarily for the salary, area salary. They have regularized the period of absence matter, holding that leave without pay. And they have also annexed the medical report, my lord. Page annexer 1, annexer I, page 64. Where they have annexed the medical report, which I have also annexed. They have not denied that I was not ill. Where you will also find at page 64 of the affidavit counter. You are also psychologically affected, my lord, so he got the psychiatric treatment also. And pre-morbid personality was normal, and he was diabetic mellitus. Totally on medical ground, manner, so they could even address it with my unleave and medical leave. They have not done it.
Where is the conclusion of the disciplinary authority again?
Inquiry report I sought, manner, they could not say. They have said they have lost or either misplaced the record, manner.
Or
He did not participate, Lordship.
did
Instead,
participate.
paper publication and all these
There
things.
is ex parte,
Lordship. It
So,
was ex parte, Lordship.
And where is the where is the conclusion of the disciplinary authority order?
Lordship. Lordship, it is in affidavit in opposition filed by the respondent, Lordship, number 5, in page 57, Annexure D, Lordship.
Yes.
This was the inquiry officer, then another notices, then second show cause notice, then the order, Lordship. Annexure G, page 60.
Hmm. 57 only the inquiry conclusion there, record is not there.
No.
Only conclusion.
This is regarding appointment of inquiry officers and all this, Lordship.
Yes.
Then another, after the inquiry was, that means it was constituted, then there was again notice was published, Lordship.
Yes, that
So
is-
the newspaper, then the second show cause notice, the departmental, these things, Lordship. Withholding of 2 annual increments with cumulative effect, Lordship.
Let them produce a record, my lord. Even if it is ex parte inquiry, my lord, there is some procedure to be followed.
Procedure is all before your Lordship, Lordship. We have stated in the affidavit and they have not denied these things, Lordship, in their reply.
If the records are not.
Now what is the conclusion arrived at? By the departmental proceeding,
Lordship, this one, Lordship, conclusion is
page 60.
page 60, Lordship. I'm not reading the whole thing, Lordship. From
Also of 2 inclement.
Yes, whereas on careful examination of the report of inquiry officer and having regard to the evidences adduced during inquiry, the undersigned agreed with the findings of inquiry officer that the charges have been proved beyond reasonable doubt and therefore provisionally come to the conclusion that the departmental proceeding drawn up against the delinquent be disposed of by awarding punishment withholding of 2 annual increments with cumulative effect. A second show cause notice was issued accordingly, whereas the delinquent duly received the served show cause notice, but after expiry of the stipulated time period for reply to the notice, no reply or any other communication against the proposed action was received from him. As such, the undersigned has finally arrived at a conclusion that the departmental proceedings against the delinquent is hereby disposed of by awarding the punishment, withholding of 2 annual increments with cumulative effect. The departmental proceeding drawn up against so-and-so thus stands disposed of with the date of the order.
Against that, any appeal filed?
No, they have not filed any appeal, Lordship. This has they have not referred, Lordship.
My lord, I sought for, my lord, some records of the case. Your lordship can see is late as 11/7/2024 also. Before filing this annexed.
Now, what is your prayer before the court?
My prayer is, my lord, that what is there in my prayer, that stoppage of my non-payment of my salary for 457 days. And my lord, even if the inquiries were held in ex parte, there is a procedure to be followed under Rule 9, whether I appear or not, whether I contest or not, but whether they have done or not. They have not annexed. I have asked for the record, and they have said it is not available. That can is ground. They are bound to furnish the record of the inquiry. Let them produce the file. Next month
You
is.
won't file an appeal, you should have filed an appeal.
Yes, Lordship, the statutory appeal, they have to, Lordship, they have
No,
to.
statutory lordship, if you, unless I get the record, what is the witnesses said, what are the, who is the witnesses, how can I?
Inquiry report not furnished.
No,
It's furnished, Lordship, because he is not, everything was furnished
He
to
was
him,
sitting in
Lordship.
my lord authority.
He abstained from that is
Anyone?
joining the enquiry proceedings, Lordship.
He was,
There was publication in the notice also. If it, at all, Lordship, he was not in a position, then his relatives were there. If they are now stating that he is with his brother and all this, they could have with the proof that the person who was suffering. Nothing was there, Lordship.
medical.
They just
all medical
kindly sir, let me
all
submit.
right from the beginning.
So
Indian onwards.
this is their Lordship, and we have annexed all these, Lordship. There was publication in the newspaper also, local newspaper.
We'll continue.
Yes, Lordship.
4th December.
Okay, Lordship.
4th December.
Yes, let the letters produce a file. Let me see what is there in the record.
The government council will also keep the relevant records of the disciplinary proceedings available.
Then, Lordship, it may take a little longer, Lordship. This has to come from Kachar, Lordship.
Relevant records necessary for
12 December.
perusal of the court. You can
Oh,
also
fine.
this counsel for the government prays for further time. For such circumstances, let the matter be called up again on 8th of January.
Lordship. 8th January, yes, Lordship. This will be fine.
You know,
Part of madam. Part of.
all right.
Your lordship is working whole day today, even at Tribunal set one.
Hmm?
এটা তো আমি উঠা নাই